going? All right. Good morning, everybody. 5 months. A long time. Who of us, including us, would have known 5 months ago, stepping through those doors, it would all come to this moment. But that's what it comes to. And this is the last time I get to talk to you. So I want to say something first, and then I'll move on. Not a lot of quotes or things like that. Just a thank you. I really thank you. I thank you on behalf of myself, and I thank you on behalf of my team. Jessica Stebbins-Bina, Katherine Cahan, Sabrina Strong. And we're just the face of it. There are others. I also thank you on behalf of my client, AEG Live, Sean Trell. Remember Sean? Here every day, just like you. And he's been here every day because of how important this is. Think about what they've been accused of doing. And that's why they're here every day. Is that yours? Don't worry. We had that during trial, we know. So, thank you guys. All right. I'm going to move through this as quickly as possible. 5 months of stuff, it's a lot of stuff. And don't worry, I'm not going to cover all of it. But I am going to cover the stuff that I think you need to remember. I'm going to point out some exhibit numbers. You might want to write them down, Hope, so that you can go back and look at them. Because remember, you're going to get all this stuff, and you can ask for anything. You can ask to look at any of that stuff. And I'm going to quickly go through it. If I'm going too fast, just twitch or something, and I'll try to slow down. Now, in this 5 months, you've heard a lot of testimony. You've seen a lot of exhibits. You've watched us attorneys make all kinds of arguments. But through it all, through these 5 months, the central focus of why we are here remains the same. And he certainly wasn't going to take no for an answer. Remember, I have to drink a lot of water. But not taking no as an answer should come as no surprise to y'all. It was his tour. It was his comeback. And as Karen Fay told you, Mr. Jackson was not someone who took no for an answer. Now, you remember Ms. Fay. They brought her back a couple times. She was Mr. Jackson's friend, confidant for decades, one of plaintiff's star witnesses. The one person Dr. Metzger testified was always with Mr. Jackson. And what did she tell you when she was on the stand? She told you that Mr. Jackson would not take no for an answer. If he wanted something, he got it. That's how she described him. And who would know better? Mr. Jackson didn't take no for an answer with Dr. Murray. And why would he? Didn't he have the right to choose his own doctor? AEG Live certainly didn't have that right. They didn't have the right to tell him, now you can't see your longtime doctor anymore. Mr. Jackson said he needed to be a well-oiled machine. Do you remember those words? He needed his doctor to keep him in top shape for the tour. And that was reasonable. He was doing 50 shows over the span of 9 months. He was a 50-year-old man. He was taking his 3 children with him. Taking his longtime doctor with him, that was reasonable. And remember, when you look at the facts, when looking at what was reasonable, you have to go back to 2009. It's not what we know today. It's what did they know in 2009. In 2009 was a long time ago. Barack Obama had just been sworn in as president for the first time. We were on the verge of what everyone thought was going to be the next Great Depression. Sometimes they said Great Recession. That was 2009. You have to go back to that time and not what we know now. And that's because what you know, what we all know now, is very different. We know so much more because of plaintiffs. Plaintiffs brought this lawsuit. And by bringing this lawsuit, they made it possible for the first time for AEG Live to get access to some of Mr. Jackson's most personal, most private material, like some of his financial and medical records. That wasn't possible before. So we now know that Mr. Jackson was nearly $500 million in debt. We know that now. We didn't know that then. We know that his mother's house was nearing foreclosure. But we didn't know that then. That's what we know now. What else do we know now? That Mr. Jackson spent decades shopping for doctors to give him the painkillers that he wanted. That he manipulated and he lied to those doctors who he saw so he could get double doses. But we didn't know that then. Mr. Jackson made sure we didn't know that then. And we now know that his family tried and failed on numerous occasions to stage an intervention. Many of them. You heard about them. We didn't know that then. Nobody did. They made sure nobody knew it. And in 2009, AEG Live had no idea of how or for what Dr. Murray was treating his patient, Michael Jackson. That was between Dr. Murray and his client, his patient. That's what the patient-doctor relationship is. All AEG Live knew was Dr. Murray was Mr. Jackson's longtime doctor. That's it. And of course, neither Mr. Jackson nor Dr. Murray told AEG Live what they were actually doing in the privacy of that locked bedroom at night. Behind locked doors, security out front, behind the gates of 100 North Carrollwood. They didn't know what was going on in his house. How could they? Think about that. If AEG Live had known, it would have ruined everything. So they made sure AEG Live didn't know. Why? Well, Mr. Jackson wanted this tour, and he wanted it badly. You heard Mr. Jackson's doctor of 30 years, Dr. Metzger. He told you last week that Mr. Jackson wanted redemption. That was his word. Mr. Jackson wanted redemption. And this tour would redeem his image with the public. That's what they hoped. An image that had undergone a serious beating in the prior years. And this tour was also going to redeem him financially. That's why Mr. Jackson didn't tell AEG Live the truth. So both Dr. Murray and Mr. Jackson, the doctor and the patient, always told AEG Live that Mr. Jackson was okay. You've heard this every single time. He's okay. Everything's fine. There are no problems. They told AEG Live to stick to its job, promoting concerts, to stay in their lane. They were the ones told, stay in your lane. Dr. Murray and Michael Jackson would handle Mr. Jackson's health. And doesn't that make sense? He's a grown man. and he has a doctor. They will handle his health. That was their job. Remember, you never heard Mr. Jackson and Dr. Murray ever coming to AEG Live and saying, wow, we got a problem. They never came and said, Mr. Jackson needs a break. They never came and said, we got to take a little time off. They never came and said, I'm sorry, he's addicted to drugs. We're going to do something about it. They never did that. And now they want us, AEG Live, to be to blame for that? Think about that. They were never told that Mr. Jackson needed to stop. Mr. Jackson never said it. His doctor never said it. They said the opposite. They needed to go on and could go on. They never told the truth to AEG Live. And they did everything they could to make sure AEG Live never knew the truth. They would keep it from them, and you heard that they did. AEG Live only learned the truth after Mr. Jackson passed. When Michael Jackson's bedroom was searched by the police and its secrets were revealed. When the world and AEG Live learned for the first time what propofol was. You remember, no one knew what propofol was. No one had ever heard it before. Never before Mr. Jackson's death. And AEG Live had no idea. Simply stated, AEG Live never would have agreed to finance this tour if it knew Mr. Jackson was playing Russian roulette every night in his bedroom. It would have never happened. But they didn't know that. Now it's true. AEG Live, Mr. Phillips, Mr. Gongaware, they all wanted to do this tour, there's no question. And they were incredibly excited about it. They wanted it to move forward. They wanted to be part of Mr. Jackson's redemption. And yes, they also wanted to make a profit. There is no question about that. But that doesn't change the facts. It doesn't change that adults are responsible for the choices they make. Now, Mr. Panish told you yesterday that it was unreasonable for AEG Live to believe Mr. Jackson. It was unreasonable to trust him. It was unreasonable for him to want a doctor to help him stay in top health. It was unreasonable for him to take his longtime doctor on tour with him and his family to London. It was unreasonable for AEG Live to respect Mr. Jackson's adult choices. Think about that. And think about this. You heard Katherine Jackson testify in this case. She said she wanted it to be a search for the truth. Mr. Panish said the same thing in his opening statements, search for the truth. And he repeated it again and again yesterday. Mrs. Jackson said that she wanted to understand, to know what really happened to her son. But Mrs. Jackson also testified, remember this, that she closes her ears when she hears bad things about him. She doesn't want to believe he had a problem. And that is understandable. One cannot blame her for that. She's his mom. Anyone who's ever known an addict can understand how that is. But as a result, she closed her ears to the choices that Mr. Jackson made. She closed her ears to the fact that Mr. Jackson overdosed. That he overdosed on a drug that he chose. And that he had been repeatedly warned about, given to him by his own doctor. And now, Mr. Panish needs you to close your ears to the simple truths of this case. The truth that it was Michael Jackson that chose Dr. Conrad Murray. The truth that it was Michael Jackson who asked Dr. Conrad Murray to join him on the tour. The truth that it was Michael Jackson who offered the $150,000 a month. The truth that it was Michael Jackson who brought Dr. Conrad Murray from Las Vegas to Los Angeles. And the truth that it was Michael Jackson who demanded the propofol, a drug that he called milk. All AEG Live was going to do is advance the money for the salary that Mr. Jackson was going to pay Dr. Murray if he went on tour to London like so many other people on the tour. And I told you that in opening statements. We've never run from that. That is true. But that doesn't change any of the facts that you learned in the 5 months since. Mr. Jackson was going to pay Dr. Murray ultimately, as he was everything else on the tour. And AEG Live never even advanced that money, ever. It never paid Dr. Murray anything. And that is because he was never hired by AEG Live to go on tour. If they'd hired him, they'd have paid him. They didn't hire him. They never gave him any money, and you saw that evidence. All these truths, they need you to ignore them. They need you to shut your ears to them. Because that's the only way that those 5 questions they told you yesterday, that's the only way you get a yes in those. And you saw here in this trial that plaintiffs, in fact, are not searching for the truth. How many times did you see Mr. Panis show you part of a document, take an excerpt from an email? Do you remember that budget where they didn't show you the footnote? How many times did we have to come and say, wait, put that in context? You never heard us do that. Remember Miss Fay, Miss Rowe, Miss Sankey? How many times did they sit there and go, let me explain that? That's not what I meant. Did you ever say, did you ever hear me go, I want a yes or no? No. We let them talk. I'm sure you remember. And there's a reason for that. The truth isn't something AEG Live's afraid of. Why would we be? We wanted the whole truth from every witness, even theirs, even their version of the truth. And all those emails, trust me, there are a lot of emails there I'd love not to have been here. Okay? Saw all those emails? Tens of thousands of them. Whose emails were those? AEG Live's. They turned those over. They're not hiding anything here because AEG Live is not afraid of the truth. The truth here is a tragedy. Make absolutely no mistake about it. This is a tragedy. It is a tragedy for this family. It is a tragedy for this mother. It is a tragedy for these kids. It's horrible. And it's incredibly sad. But it is not a tragedy of AEG Live's making. You can't point the finger at them, and you shouldn't. Now, members of the jury, I ask you, please, don't close your ears to the facts. When you're answering the questions on that verdict form, think about who chose Dr. Murray. Who hired him? Think about whether AEG Live knew what was going on in Mr. Jackson's locked bedroom at night. Think about whether you believe AEG Live caused Mr. Jackson's death. Think about that, because that is the real question here. Did AEG Live cause Mr. Jackson's death? Because that's what they're saying. Mr. Jackson chose this doctor years before. And Mr. Jackson chose the drug that killed him. Mr. Jackson, like every adult, is responsible for his own choices. You heard them. He's no different. And sometimes we make really bad choices. It's true. And it'd be awesome when we make those changes to turn and point to somebody else. It wasn't me. But you can't do that. That's what it means to be an adult. That's what personal responsibility is about. He made some bad choices. And it resulted in a horrible tragedy. But you can't and shouldn't blame someone else for Mr. Jackson's bad choices. He was a grown man. Alrighty. I'm going to give you a little roadmap. You remember from trial, I often like to point out where we're going to go so you have some sense of what we're going to do. I believe that plaintiffs have focused this case on a lot of distractions, okay, not the facts. A lot of things were thrown at you that I don't think are relevant to your determination. I think you saw that throughout the course of the trial. For example, they put on evidence that Mr. Jackson was ill at a rehearsal a couple days before he died, June 19th. Remember that? Ill? And that people told AEG Live about it because they weren't there. And you remember those trouble at the front emails, chains that you were shown over and again, or portions of them? You remember how they'd ask every witness, anybody who walked up, what do you think that means? Even people who weren't on them, knew nothing about them, showed again and again and again. Let me be clear about something. AEG Live did discuss Mr. Jackson's health in those emails because they were asked to. That is what they were about. We're not disputing that. There's no dispute about that. But you're not being asked to decide here what AEG Live knew about Mr. Jackson's health. Look at your verdict forms when they come. You're not asked to decide what they knew. What did they know about his health? What should they have known about Mr. Jackson's health? Whether they knew he was sick on June 19th. And you'll see why I say this. Look at the verdict form. You know what? I don't know if you still have. Can I get the verdict forms? Is that right, Your Honor? Thank you, sir. This should be the same one. So what I'm going to do is I'm going to do a little bit like what I did during trial, which is, you remember, they would go in a certain order. Then generally I would go backwards through that, take the most recent and go back. So for this instance, I'm going to go through the same order. And there's a reason for that. That's because, you remember, what they have the burden of proof. You have to answer yes to every question before you're going to find liability and get the damages. You find no on any of these, which I believe you will, it's done. So that's why I want to go through it in that order. Because you have to say yes to all of these before you get to finding them money. And I believe along the way, you're going to say no. So we're going to take them in order. And these are the questions that you'll fill out. And every one of those questions, if you look at it, I was talking about the idea that this is not about Michael Jackson's health. You'll look, it's because this is about Dr. Conrad Murray. Look at the questions. Every one of them has to do with Dr. Conrad Murray, not Mr. Jackson's health. That's because they're suing AEG Live for a claim called negligent hiring, retention, or supervision of Dr. Conrad Murray. They say AEG Live hired Dr. Murray and that we were negligent in doing so. So you have to find two things. Did we hire him? And if we hired him, were we negligent in doing so? The negligent hiring claim protects people from bad hires. It does this by holding an employer liable when someone the employer hires hurts or kills someone else. And Mr. Panish said yesterday the law makes sense. It's fair. Justice is for everyone. And I absolutely agree with that. Justice is for everyone. And it is fair in this case. But what's not fair or just is to find AEG Live at fault for what happened to Mr. Jackson here. Because the law of negligent hiring only holds an employer liable, only at fault, if he knew or should have known that the person he hired might harm someone, but still hired or kept them on anyway. Like giving a person with a history of violence a job where he had to use a weapon. If you knew that he had a history of violence and you gave him a weapon, that would be a negligent hiring. Or keeping a driver after multiple arrests for reckless driving. You knew he had multiple or she had multiple arrests for reckless driving, and you kept him on anyway. That would be a negligent retention. And this only makes sense. It wouldn't be fair to hold an employer liable if they had no reason to know that, if they had no reason to believe that the person they hired was dangerous. That wouldn't be justice. You have to be on notice. Remember that word. You have to be on notice that there would likely be a problem. And that's important here, because as the court told you on Monday, I know, it seems like a lifetime ago, but just 2 days ago, you can only find AEG Live at fault here if it knew or should have known that Dr. Murray was dangerous, but they hired him anyway. Or AEG Live hired Dr. Murray, then found out that what he was doing and didn't get rid of him. That's what the actual law is. So this case is about what AEG Live knew about Dr. Murray. Look at the questions. It's about Dr. Murray. Not what it knew about Mr. Jackson. And that's the diversion they've tried to take. Because you can't answer yes to these if it focuses on Dr. Conrad Murray. Look at the verdict form. You'll see that. And trust me, I'm going to go through it. And as the judge told you, plaintiffs have the burden of proof on this claim, not AEG Live. As you go through those, they have the burden. They have the burden of proving each and every element of their claim. And those elements are laid out on that same verdict form that you have to fill out. And plaintiffs must prove 5 different things. If they haven't proven even one of them, they haven't proved their case. And that's their burden. And we're going to talk about each just real quickly right now. Ready, Pam? Okay, first, have plaintiffs proved to you that AEG Live hired Dr. Conrad Murray? I think that question's easy, and we'll go through it. Because if anyone hired Dr. Conrad Murray, it was Mr. Jackson, not AEG Live. Second, if you nonetheless find that somehow AEG Live hired, you go on to the next, and that says, have plaintiffs proved that Dr. Murray was unfit or incompetent? And by the way, that's where they stopped yesterday. They only ask you if he was fit or incompetent. But that's not the question. The question is, was he fit or incompetent for the job for which he was hired? And that's the key. Dr. Murray was fit and competent to take care of the general medical needs of Michael Jackson, and that's what he was hired for. He had been doing so for the Jacksons and his other patients for years, without incident. The answer there has to be no. Third, have plaintiffs proved that AEG Live knew or should have known that Dr. Murray was unfit or incompetent, and that this put others, including Mr. Jackson, at risk of harm? In other words, did AEG Live know, or should they have known, what Dr. Murray was actually doing? Again, the answer in the evidence shows you that that has to be no. Fourth, if you get there, have plaintiffs proved that AEG Live's negligence, because what you're looking up before is to try to prove were they negligent, goes on to say, if they were negligent in the hiring, supervising, or retaining of Dr. Murray, was that a substantial factor, that supposed negligence, in causing Mr. Jackson's death? In other words, you can hire someone, it could be negligent, but if it's not the factor, if it's not the substantial factor, and again, they said there could be more than one substantial factor, but if that's not a substantial factor, well, in that case, you're going to have to say no. And the sad truth here is Mr. Jackson's death was caused by his choices. And it would have happened, no matter what, with or without AEG Live. How do we know that? AEG Live didn't hire him. They didn't advance any monies, and it happened anyway. Again, I think the answer there is no. Fifth, if they've proven all of those things, well, then they got to prove damages. And damages isn't something where you sit there and go, whatever you guys think. Okay? Isn't it as easy as that? You've got to have some proof. Okay? You've got to have something. And their dollar amount is $1.5 billion. They kind of rushed through that yesterday. I don't know if you noticed. Maybe they're a little embarrassed to throw it up on the screen, but it was there. $1.5 billion. I'm sorry. That's an absurd number. Absurd. And they haven't even remotely proved it. Not in any way. We'll go through it, but you remember that all that testimony from their supposed damages person. But the years and years of future recordings and not just recordings, but on tours that he was going to do. Because think about that. Their claim is he was so sick, and it was so obvious to everyone that AEG Live should have known that. Again, shifting the focus to him, because they can't focus on what they knew or didn't know about Dr. Conrad Murray. He's so sick that everyone should have known it. And then they turn around and say, but he was going to go on and make more money than anyone had ever done in history with 4 more world tours? It doesn't make sense, like the rest of their claims. Again, can't guess on that one. You've got to have some basis. You can't speculate. That's what the law says. So I'm going to quickly talk about something briefly, and then we'll go through them. And I want to talk about it because it's important. You've heard lots of testimony in this case about things people knew, about people who knew Mr. Jackson and what they did or what they didn't do, including AEG Live. Karen Fay, I'm not going to go through all of them, I promise, but Karen Fay, clearly she loved him, had for a long time. Yet she didn't confront Mr. Jackson with her concerns about his drug use. She didn't even ask him what was wrong on the 19th. She thought it would be wrong to do so. Now, if I recall, she thought they were best friends. But she didn't do anything. She said nothing to him. Elif Sankey. She says that she thought she should have called 911. She wanted to, but she didn't do it. Dr. Alan Metzger. Remember, he talked about advising Mr. Jackson just before his death that he should go get some sleep care. Even though he did that, and even though he was concerned that Mr. Jackson had a profound sleep disorder, he didn't follow up. One of his best friends, a person of 30 years. You heard Dr. Sherilyn Lee. She failed to talk Mr. Jackson out of using propofol for sleep, though she tried. She, too, never followed up. I can keep going. Travis Payne. He couldn't convince Mr. Jackson to do physical therapy. Randy Phillips. He didn't force him to see a psychiatrist. I can go through and through and through with everyone because whenever a tragedy happens, it's easy to play that game. You can torture yourself. I'm sure his family has tortured themselves, and they shouldn't. You sit there and you say to yourself, if only I had done something. If only I had seen the signs that are now so clear with 20/20 hindsight. Or you can torture others. You can blame them. Tell them that if only they had done something, if only they had seen the signs that you can now see with 20/20 hindsight. That is a natural thing to do, but as adults, it's not what we should do. Because as the judge has instructed you, these kinds of should have, could have, would have, they aren't part of the decision you're here to make today. The law doesn't require you to save someone, even if your conscience, your morality, your love, your guilt, whatever it is, even if that tells you you should. That's not the law. There's not a duty to save. And who would ever, anyone who, and again, I talked about the idea before, anybody who's ever loved an addict, known an addict, cared for an addict, knows what that's like. You can't save someone. They have to save themselves. And more important for what you're doing here today, the law doesn't say you have to. Because if it were any different, if that weren't the case, everyone would be legally responsible for everybody else's decisions. And that's not how life works. And it's certainly not how the law works. All right, so we're going to go through the 5 things the plaintiffs have to prove. And we're going to go through them because I believe they haven't proved them. And unlike yesterday, the way we're going to do it is we're actually going to go through and I'm going to give you all kinds of facts that you've seen so that you can put it in a context to understand what you're going to decide. So the first one on your verdict form is hiring. The first question obviously had to be hiring. Who hired Dr. Murray? Because someone can only be liable for negligent hiring, retention, or supervision if you hire that person in the first place. You can't negligently hire someone unless you hire. You can't negligently retain unless you hire. You can't negligently supervise unless you hire. So the first question is, who hired? And you're going to be asked on that verdict form exactly what it says here. Did AEG Live hire Dr. Conrad Murray? It's the opening question. Has to be. Now, remember, it's plaintiff's burden to prove that AEG Live hired Dr. Murray. And I believe that answer is no. AEG Live did not hire Dr. Murray, and I believe it for 2 reasons. And I'm going to go through both. The first is that the evidence is very clear that Michael Jackson was the one who hired Dr. Murray. And we'll talk about that. But the second reason, which we'll talk about in a moment, is that things never even got that far. There was never a contract. Plaintiffs want you to believe there was a done deal somehow between AEG Live and Dr. Murray sometime before June 25th, 2009. And even they can't really say when. They throw up a bunch of numbers. It was then, or maybe then, or maybe then. That's because there was never a done deal. And as the judges instructed you on Monday, plaintiffs have to prove that AEG Live and Dr. Murray agreed to be bound without a written agreement. They have to, for all their theories, they have to have agreed to be bound. And they have to agree to be bound without a written agreement, because we know there isn't one. And therefore, for either of those 2 reasons, I think your answer will be no. Now, let's talk about the first one. That it was Michael Jackson and Michael Jackson alone who hired Dr. Murray. Now, as the judge told you on Monday, there are 4 options here. And that makes sense. There could only be 4 options here. Either Michael Jackson hired him, AEG Live hired him, they both hired him, or neither one hired him. And I believe all of the evidence you've seen, evidence, not what people have argued. Because remember, what I say, what the lawyers say, that's not evidence. The questions aren't evidence. Let's look at the evidence. And I think all the evidence shows that the only person who hired Dr. Conrad Murray was Michael Jackson, not AEG Live. Now, how do we know this? Well, Mr. Jackson selected Dr. Murray. We know that. There's no dispute about it. We know from Dr. Murray's records that he had been treating Mr. Jackson and his children since 2006. Now, I want to say something about those records. Don't forget, We didn't get everybody's records, and even when we got someone's records, we could only get part of them. So we're basing this on all the records we could get. There are unquestionably many more medical records out there. We didn't get them, though we tried. But from what we got, we know that at least since 2006, he was treating Mr. Jackson and his children. I don't think there's any dispute on that. You also heard the testimony of Jeffrey Adams, Mr. Jackson's former bodyguard. Remember, he's the one who introduced Dr. Murray to Mr. Jackson. Mr. Adams went to Dr. Murray's office in Las Vegas, as did his father. In fact, Mr. Adams' father was Dr. Murray's patient as well, just like Mr. Jackson. Mr. Panish tried to insinuate that Dr. Murray didn't have real practices. Do you remember that? He said it. No witness said it. Dr. Murray was a real doctor. All the evidence shows that, and he had real patients. Do you remember Stephen Gordon, Dr. Stephen Gordon from Las Vegas? Dr. Murray introduced himself to Dr. Gordon as Mr. Jackson's personal physician in 2007. Remember Dr. Slavitt? That was the doctor who gave the physical in February 2009 for the insurance. He testified that Mr. Jackson told him that Dr. Murray was his personal physician. It's Mr. Jackson saying that. That was in February, before AEG Live had ever met or heard of Dr. Conrad Murray. He didn't give some other name. He was asked who his physician was. He didn't say Dr. Metzger. He didn't say Arnie Klein. He didn't say any of the many other doctors you heard. He said Dr. Conrad Murray. Dr. Murray was Mr. Jackson's long-term doctor. They can play that off as not true, but it's true. And the evidence shows it. That is what he told everyone. And he told them this long before AEG Live had ever heard of him. And Mr. Jackson was the one who brought Dr. Murray to Los Angeles. You've seen the evidence. Dr. Murray was in Los Angeles treating Mr. Jackson long before AEG Live had ever heard of him. He treated the Jackson children for colds in January 2009. That's in the medical records. He was seen at the house multiple times a week from at least the very beginning of April. We know at least that long. You've heard that from Kai Chase, remember the chef? Who testified that when she started working in Carrollwood, he was there. That's April. You also heard from Travis Payne, the choreographer, the one who went on the tour, and Kenny Ortega, the director. They told you how Mr. Jackson introduced Dr. Murray to them. Mr. Jackson introduced Dr. Murray to them in his house as, quote, my doctor. I'd like to introduce you to my doctor. And that's what they did when they met him. And that's the spring of 2009. You've also heard the testimony of Paul Gongalware and Randy Phillips that Mr. Jackson insisted that Dr. Murray come on tour and would not take no for an answer when they suggested anything else. Get someone in London. It'll be cheaper for you. Get someone in London. There are great hospitals. No, I'm taking my doctor. Dr. Murray had been Michael Jackson's doctor. He was Michael Jackson's doctor, and he was going to continue as Michael Jackson's doctor. And it was not for AEG Live to interfere with that long-time doctor-patient relationship. That's what they're asking you to do, interfere with that relationship. Dr. Conrad Murray was Michael Jackson's choice. Okay, so we know Mr. Jackson was the one who selected Dr. Murray. I don't think there's any debate about that. Now what about payment? Well, Michael Jackson did that too. In fact, Michael Jackson had been paying Dr. Murray for 3 years. You saw that testimony, bless you. The whole time Dr. Murray was treating him. And Mr. Jackson continued to pay Dr. Murray in Los Angeles. You saw that testimony. Remember, he had his children, Prince and Paris, give Dr. Murray stacks of $100 bills. You remember that? We sat there and I go, how thick? This thick, that thick, this thick? He said it was this thick with rubber bands, $100 bills. And Mr. Jackson paid Dr. Murray through the day that he died at least 10 times in Los Angeles. That was the testimony. That's Mr. Jackson paying, not AEG Live. And did AEG Live ever pay Dr. Murray? No, never. The evidence is absolutely clear on that. They never paid him because they never hired him to go on tour. Mr. Panish said yesterday that AEG Live was, quote, giving the money to Dr. Murray, end quote. That is not true. AEG Live never gave any money to Dr. Murray, ever. That's the evidence. Now that said, and you should listen to me on this one, even if, and this is a little wrinkle, even if there had been a contract, this is the first part, remember the second part, wrinkle, even if there had been a contract, this is the first part, remember the second part I'm going to say there's no contract, even if some contract between AEG Live and Dr. Murray had been completed, let's just say it had, no, it wasn't, but let's say there was some contract, I don't know what it would be, okay, conduct, oral, some of the many theories that they've thrown, okay, say that happened, it still would have been Mr. Jackson that was paying Dr. Murray, remember? He was going to be engaged at Mr. Jackson's request and at his expense. This is one of the draft contracts that went back and forth between Dr. Murray and AEG Live's outside lawyer, Kathy Jory. Now this is Exhibit 343. I'm going to say it again, 343. It's one of the drafts. And as you remember, whenever we could, we would show it with somebody on cross because they weren't showing it. And each of these drafts, every one of them, had a signature block from Michael Jackson, like the one here on page 6 of Exhibit 343. And as you remember, each one said, and I'm going to quote it, the undersigned, that's Michael Jackson, hereby confirms that he, no, I have it misspelled here, I know I do, yes, he has requested, producer, to engage Dr. Murray, he requested it, on the terms set forth herein, on behalf of, and at the expense of, the undersigned. Who's the undersigned? Michael Jackson. So if there had been a completed agreement, if there was any agreement, it would have been on behalf of Michael Jackson. It would have been at the expense of Michael Jackson. Dr. Murray's payment would have come out of Mr. Jackson's money, his portion. All AEG Live was ever going to do was loan it to Mr. Jackson. They'd loan that money, and they were only going to do that if Dr. Murray ended up coming on the tour. Just like they did for his house, just like they did for his art. Remember when I bought art and they were paying for it? That's because he was $500 million in debt. That's why he went to AEG Live. They were going to advance in the monies because no one else would anymore, remember? They shut off the credit cards. Remember that? They couldn't get the advance? Or what was it? No, the increase? Mr. Jackson was also going to be taking responsibility for Dr. Murray. Now, you saw the contract between Michael Jackson and AEG Live for the tour. Not these drafts, but the one between Michael Jackson and AEG Live. And that's Exhibit 66. That's the actual agreement they had. And this is a contract for the shows that were going to be in London. Well, that contract gave Mr. Jackson the right to bring a tour party, it's called a tour party, to London with him. That's what he was allowed to do. It's his tour. And that's not unusual. Artists often want to bring their personal entourage with them on tours. But the artists are responsible for choosing those people, and they're responsible for what those people do. And this was no different. Let's look at paragraph 15.2 of the tour agreement. That's on page 11 of Exhibit 66. The tour agreement says that Mr. Jackson is responsible for the people he selects and brings. Artist Co. and artist, so that's Mr. Jackson and his company, shall defend, indemnify, and hold promoter, say AEG Live, harmless for any third-party claims arising out of or relating to the negligence or wrongful acts or admissions of the tour party. He takes responsibility. He had to. They're his choices. He can bring who he wants, but if the people he brings act negligently, the buck stops with him. Now, yesterday, plaintiffs tried to argue otherwise. They tried to say the draft agreements, that provides that AEG Live was going to be controlling Dr. Murray's actions in some way. But this is one of those places where plaintiffs didn't tell you the whole story. Kathy Jory, on cross, told you it was never the intent of anyone at AEG Live to control Dr. Murray's treatment of Mr. Jackson. And you can see that from the evidence in this case. Because during negotiations, Dr. Murray called Ms. Jury and asked her to change the contract. To make it crystal clear, he reported only to Mr. Jackson, not AEG Live. Remember that testimony? He said it. He got a draft and said, no, you got to change this. I don't answer to you. I answer to my client. I answer to my patient. I answer to Michael Jackson, the one who's hiring me. And she made the change immediately, and you saw it. She changed the language because Dr. Murray and AEG Live both understood that Dr. Murray was working for Michael Jackson, not AEG Live. And remember, under the agreement that Ms. Jury was drafting, it was Mr. Jackson, not AEG Live, who had the right to fire Dr. Murray. AEG counsel could cancel the agreement, but only under certain conditions. If you look at it, there are conditions on which they can say, okay, we don't have to advance this money anymore. Like Dr. Murray having insurance or the tour not going forward. If those weren't met, then yeah, they didn't have to advance that money anymore. But Mr. Jackson's the only one, look at it, who could fire Dr. Murray at any time for any reason. Because that's what you do with a patient-client, patient-doctor relationship. That's what you do. You have the right to fire them at any time if you want. Now, the evidence is overwhelming that the only person who ever hired Dr. Murray is Michael Jackson. So that is the first reason, I believe, that you have to answer no, okay, in question 1 on the verdict form. I think all that evidence. It's no, and I think it's clear who hired him. Put down no, it's over. But as I told you, there's a second reason. There's a second reason to put no there. And that's because AEG Live never had an agreement with Dr. Murray. An agreement to hire him or for anything else. The only thing AEG Live was ever going to do with regard to Dr. Murray was to advance his salary on Mr. Jackson's behalf, with Mr. Jackson ultimately paying for it. But even that never happened. As Mr. Panish said yesterday, plaintiffs are claiming AEG Live hired Dr. Murray through a written contract or an oral contract or a contract implied by the parties. Plaintiffs haven't proved any of those things. That's because they can't. They can't prove that any such contract ever existed. And it's their burden. Remember that. It's their burden to prove that. If there's no contract, there certainly was no hiring. Now let's look at the instruction the judge gave you on what is required for a contract, whatever type. In deciding whether there's a contract, you have to show yourself under the you have to ask yourself under the circumstances whether a reasonable person would conclude based on the words and conduct of each party that there was a contract. That's what you look at. But going further, and this is important, quote, you may not consider the parties' hidden intentions, end quote. In other words, you're looking at what the parties actually said, what they actually did with each other. Each party has to know. That's not what one party did. Oh, they did that, so therefore there must be a contract between these two? No. You have to look at each. Okay, nothing hidden works here. And what did AEG Live say and do that Dr. Murray actually knew about? And what did Dr. Murray say and do that AEG Live actually knew about? And the judge told you it is plaintiff's burden to prove to you that Dr. Murray and AEG Live agreed to be bound without a signed written agreement. That's the instruction. All right? Remember that. Plaintiff's burden to prove to you that Dr. Murray and AEG Live agreed to be bound without a written contract. Plaintiffs never proved that because they absolutely cannot. Both AEG Live and Dr. Murray understood there would never be a contract until Mr. Jackson signed as well. That was what they agreed to. That's the end of the story. How do we know that? Well, it was in the draft agreements exchanged between Dr. Murray and AEG Live. It was in every single draft agreement. And it was in every single one for a reason. Let's focus on paragraph 9. And I'm going to do this in the last one, the last draft, the one that Dr. Murray actually signed on the 24th. Again, this is Exhibit 343, in case you want to go back and look at it. And this paragraph is very important. So let's look at it closely. It makes clear that the effect of the agreement is conditioned upon the approval and consent of the artist, Michael Jackson. Unless Mr. Jackson signs off in writing, there is no contract. There is no agreement between them. Dr. Murray has no rights or obligations as to AEG Live. And AEG Live has no rights or obligations as to Dr. Murray. What does that mean? No one has to do or not do anything. There's no contract. There's no agreement. Dr. Murray can still be Michael Jackson's doctor. He had been Michael Jackson's doctor. He was Michael Jackson's doctor. He could continue to be Michael Jackson's doctor. This has no impact on that. But AEG Live wouldn't be involved in any way, any shape, any form, unless Mr. Jackson signed. Without that signature, there's simply no agreement with AEG Live. Not a written contract, not an oral contract, and not a contract implied by the conduct of the parties. No kind of contract. It doesn't get really a lot clearer than this. Paragraph 9, signature in the bottom, I think it tells you what you need to know. And you've heard how special paragraph 9 is. It was only in Dr. Murray's draft agreement. It wasn't in any other independent contractor agreement on the tour. They told you that. Not in Kenny Ortega's, not in Karen Fay's, and that was because this agreement was going to be unique. When people say, no, I've never seen one like this, I've never seen an agreement like this, that's right. This was different, and that was intended to be different because Mr. Jackson had decided to bring along his longtime doctor. He wanted to bring him on tour, but he wanted AEG Live to front the money to him. That's the reason AEG Live ever even spoke to Dr. Murray. Why would they have ever spoken to him otherwise? Michael Jackson asked them to. But the only way AEG Live would agree to do that, to assume those payments for that deal Mr. Jackson had already had with his longtime doctor, the only way was if Mr. Jackson also signed on that arrangement in writing. Paragraph 9 addressed the idea that you heard Dr. Green, the expert, testify about. He said it's a fundamental right for a person to choose their own doctor. And that all stems from the personal and private nature of the doctor-patient relationship. Now you recall Mr. Trell, here every day, who testified about the importance of this condition in paragraph 9. He testified that paragraph 9 was added, quote, because of the personal request here from Michael Jackson for his particular engagement of his personal physician, end quote. Paragraph 9 was so unique, Mr. Trell testified, that it was not in any other independent contractor agreement he's ever seen in his years at AEG Live. When people say they haven't seen something like that, it's about this. Paragraph 9 was a roadblock. It made sure that no contract of any sort was ever completed without Michael Jackson's agreement and signature. And why is that so important? Because it was Michael Jackson's contract, and he had to agree to it. He was the one who hired Dr. Murray. He was the one bringing his own personal physician on tour with him. Even though AEG Live would be advancing the monies, and they would have, it was Mr. Jackson who would be paying him. Mr. Jackson had to be on board with every term of the contract, or there was no contract. It's easy to say, we knew that Mr. Jackson wanted the contract, that he was the one who demanded Dr. Murray, and he was the one who authorized the payment of the $150,000. But contracts are more complicated than just that. There were many more details involved, and Mr. Jackson had to approve all of them. Mr. Jackson could have decided he wasn't going to take Dr. Murray on tour. We still had a couple weeks. We don't know what he was going to decide. As you saw, there were many times when Mr. Jackson suddenly decided he didn't want to work with anybody any longer. He could have decided to not agree with any part of the agreement. He could have asked for additional changes or corrections to it. His people may have been unhappy with some of the wording of it. And I want to talk about that for a second. Mr. Panish makes a big deal about the fact that Mr. Jackson's people had not yet reviewed the draft contract. But obviously, they would have had to have reviewed it. You heard Ms. Jory's testimony that they wanted to get it as close to done as possible before presenting it to Mr. Jackson and his management. And you saw the declaration of Mr. Jackson's manager. You saw it. His declaration. Not somebody talking about what he said. His declaration. That was his manager, Mr. DeLeo, and he said that he knew all about the draft Dr. Murray agreements. So you can't say they didn't know. They knew. Yes, they hadn't reviewed the draft yet because they were getting it in shape enough so they could now comment. What did Dr. Murray want in this? What did AEG Live expect to do? You get it there, and then they get to look at it. Mr. Panish said yesterday nobody could prove Mr. DeLeo knew about Dr. Murray because Mr. DeLeo was dead. Yes, he is. He didn't testify. And yes, it's true some people talked about what he said. But the evidence of this is in his sworn declaration, not someone else's. It wasn't a secret, and it was going to be sent to Mr. Jackson and his people because he had to sign it before there was an agreement. Now, Mr. Jackson's signing was required because that was the only way that everyone could be sure that Mr. Jackson was agreeing to this. That's why there couldn't be an agreement without Mr. Jackson signing it. Not because AEG Live was in control of Dr. Murray. If they're in control of Dr. Murray, why would they need Mr. Jackson's signature? It's because Mr. Jackson was. Now, plaintiffs want to drive right around this roadblock. And they want to pretend it doesn't matter. Did you hear about it yesterday? That's why they tell you there were 3 different kinds of contracts that could have been made, maybe June 6th, maybe May 6th, maybe June 16th, maybe June 24th, whenever. They're sending all those cars, all those arguments at that roadblock, and they're hoping one of them gets through. Okay, when are you going to say, oh, maybe that works? But paragraph 9 was in every draft that was sent before AEG Live and between AEG Live and Dr. Murray. All 3 of them. Dr. Murray made a lot of important changes to the first 2 drafts, but he never changed paragraph 9. He made all kinds of other changes. You saw that. Kathy Drury testified about it, but he never changed this. He never said this has to be taken out. And he didn't change it because he agreed with it. He knew there was no contract without Mr. Jackson's signature. He knew who had hired him. He wasn't going on tour unless Mr. Jackson decided to take him. Okay, ready? Here's the scenario. Mr. Jackson decides he doesn't want him. So we're going to take him? Of course not. He wasn't going on tour unless Mr. Jackson decided that. In fact, on June 24th, 2009, he signed that agreement. By signing it, he's showing he agreed with paragraph 9. That is an action that he took that shows you that there's not going to be a contract unless and until Michael Jackson signs. He agreed with that. And again, look at it. It's Exhibit 343. Now, this means there's no contract, no written contract, no oral contract, and no contract implied by the conduct of the parties. That was the conduct of the parties. Plaintiff keeps trying to get around that roadblock. So they try to claim there was an oral contract instead. That doesn't fly either. Remember, it's plaintiff's burden to prove the parties agreed to be bound without a written agreement. That's their burden. If Dr. Murray had an oral agreement with AEG Live, he never would have signed a document saying he had no contract without Mr. Jackson's signature. He would have said, no, that's not right. We already have a contract. But he didn't do that because he knew there was no contract unless Michael Jackson signed.
Break.
Oh, I'm going to get in trouble. All right. You heard Mr. Panish argue, thank you, Your Honor. You heard Mr. Panish argue that a contract was created on May 6, 2009. That's the date they gave you, May 6. He says it was created simply because Paul Gonkoware called Dr. Murray at Michael Jackson's direction and said that Mr. Jackson was willing to offer $150,000 per month. You remember, done at $150K per MJ? They based that to say that's why there was a contract as of May 6th. But the evidence shows a contract wasn't created that day because the only term that was agreed to that day was Dr. Murray's salary. Lots of other important terms, like how long Dr. Murray would work for or who would be responsible for things like airfare and insurance. They weren't even discussed on that call. That's why Mr. Gonkoware contacted Tim Woolley. Remember that? Right after that call, he contacted Tim Woolley, the tour finance manager, and Mr. Gonkoware asked him to call Dr. Murray. Why? Because there wasn't a contract yet. Both sides needed more information. And more important, they needed Mr. Jackson's written approval. Mr. Woolley knew that too. You heard his testimony that he didn't think there was ever a contract with Dr. Murray.
Sir, do you recall having an agreement with Dr. Murray that you were going to pay him for May?
I didn't have any agreement with Dr. Murray.
Did AEG have an agreement with Dr. Murray?
Never.
That they were going to pay him for May? Never.
No, I don't remember that there was ever a completed agreement between AEG and Dr. Murray.
I'm not asking those questions. They are. What about Mr. Woolley's back and forth emails? The ones with Dr. Murray? Did they create a contract? Again, the evidence shows the opposite. Just look at Mr. Woolley's first email to Dr. Murray. This is Exhibit 177, and I'll finish right after this one, Your Honor. This email is a summary of Mr. Woolley's first and only call with Dr. Murray. His first and only call. Let's look at the last sentence. Mr. Woolley says there, quote, lots to consider, end quote. He's, quote, happy to continue the discussion, end quote. If there was a contract, there wouldn't be lots to consider, nor would you need further discussion. And the subsequent emails that we'll talk about after the break makes that really clear. And if there was a contract on May 6th, he wouldn't be saying this to him on May 8th. Your Honor.
Okay, thank you. Let's take a break, 15 minutes. Let's come back at 11:30.
Thank you. Thank you, sir. How's that? Okay, thanks. We're now going to direct the call.
Katherine Jackson versus AEG Live, VC 445597. Let's continue with closing argument.
Thank you, Your Honor. Where we left off was they're saying there's a contract on May 6th, yet on May 8th, Mr. Bully has sent an email after his first and only call with Dr. Murray, talks about happy to continue the discussion, lots to consider. I was going to show you the next emails, which makes it even clearer there was no agreement between the parties. What did he say there? He said they should, quote, take the next step of discussing a contract, end quote. The next step. You don't take the next step of discussing a contract if you already have one. That's on May 14th and 15th. Okay, this is nearly 2 weeks after they say there was already an agreement. Dr. Murray understood there was no contract too. Look at his response. His response to Mr. Woolley. He asked for a draft contract to show his lawyer before he signs. He wants to have his lawyer take a look to decide if he should agree to it. Should he agree to it? If he'd already agreed to something 2 weeks prior, he wouldn't need to do that. He knows there's no contract yet. Mr. Panish likes to zoom in on the part of this email where Dr. Murray says, quote, my services are fully engaged. But he ignores the most important part. Who Dr. Murray's services were engaged with. And this email exchange is Exhibit 191. If you want to look at all of them, 191. And you can see the whole chain, not just part of it, while you're deliberating. Dr. Murray says his services are engaged with his client of the last 3 years, Mr. Jackson, not with AEG Live. His own long-term patient and client is with whom he is working. Mr. Jackson had hired him. Now, Mr. Panish tried to tell you yesterday that this sentence meant Dr. Murray's client was AEG Live. Go look at the exchange, and you decide what it means. Now, Mr. Panish also likes to make a big deal about the fact that Dr. Murray asked AEG Live for a salary advance around the same time period. He likes to show you that email. Showed it many times during trial. He showed it again yesterday. But again, plaintiffs aren't telling you the whole story. And that's something I want you to remember. You need the whole story. Not just when people give you little snippets of stuff. Look at it in context. Look at what people actually meant, not what someone else characterizes it as. And what's the other half of the story? How AEG Live responded to Dr. Murray's request for a salary advance. What did they do in response? He didn't show you that. AEG Live said, no, you're not getting paid unless there's a written contract and everybody has signed it. But plaintiffs didn't show you that. You remember at trial we had to do it on cross. So what was the response? Let's look at exactly what Mr. Woolley says in response to Dr. Murray's request for money. This is Exhibit 232 at page 1. It says, quote, AEG policies dictate that payments may only be made under a fully executed agreement, end quote. This is May 28th. Executed means signed. Fully executed, just another way of saying signed by everybody. If there's no signed contract by everybody, then there's no agreement and no payment. That's May 28th. They say there was a contract on May 6th. It's simple. Michael Jackson had to sign, or there was no contract, bless you. Dr. Murray understood this. He didn't argue with Mr. Woolley. There's no response where he says, no, 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 no. I've been working for y'all for a month. You've got to pay me. I can't wait till you get a contract ready. You don't see that because that wasn't the case. He wasn't working for them. They were negotiating to see if he ever would be being paid by them, and that hadn't happened. And he didn't ask anyone from AEG Live for money ever again. Okay, what about Kathy Jury? Did she tell Dr. Murray there'd be a contract without Mr. Jackson's signature? Again, the answer is no. Remember, Dr. Murray wanted to see a draft contract before he signed anything that would bind him. And Ms. Jury sent him the first draft on June 16th, 2009. Now, they say there was a contract, 6, 7 weeks prior? June 16th, 2009. And they went back and forth through 3 drafts, each containing paragraph 9. And he made many comments and changes, but not to paragraph 9. And as Ms. Jury testified, she told Dr. Murray the same thing when she talked to him on the phone. that there'd be no oral agreement. The only agreement is if it was signed by Mr. Jackson. Let's look at the third different theory plaintiffs come up with, a contract based on the conduct of the parties. There's no written, there's no oral, so this thing may be conduct, the way they acted. And let's look at your jury instruction on that. It's pretty basic. You look at whether the conduct of the parties show they had a clear and intentional agreement. You can't have an agreement with somebody by chance. Okay? You have to have an agreement because that's what the parties intended. It has to be clear and intentional. And again, paragraph 9 is a roadblock to that because of Dr. Murray's conduct, his conduct. Remember, you look at their conduct. 12 hours before Mr. Jackson died. And what was his conduct? He signed saying there's no contract without Mr. Jackson's signature. And then he faxed it to AEG Live. There's no way to interpret that conduct as anything other than Dr. Murray knowing he needed a written agreement and it had to be signed by Mr. Jackson. Now, what about the fact that Dr. Murray was treating Mr. Jackson? Is that the conduct that means there was an agreement? Does that mean there was some conduct that you can interpret somehow as an agreement between the parties? No. The conduct has to be something that each side knows the other would interpret as a contract. That's what the instruction says. Mr. Jackson told Paul Gongaware, Randy Phillips, Travis Payne, Kenny Ortega, that Dr. Murray was his doctor. That's what Michael Jackson said. He had treated the Jackson family for years. Dr. Murray told Paul Gongaware, Tim Woolley, and Kathy Jory the same thing. Nothing about Dr. Murray continuing to treat. He had been treating for years. He was still treating. There's nothing about this that would signal to AEG Live, oh, wait, he thinks he's working for us now. Especially when AEG Live told Dr. Murray over and over again that no contract would exist, no agreement, unless everyone signed off on the agreement, unless Mr. Jackson said yes. He had to sign it. And by the way, Mr. Panish said over and over again yesterday that Dr. Murray started his services on May 6th. That's just not true. Remember what Ms. Chase said? Dr. Murray was already working at Mr. Jackson's house at least 2 or 3 times a week in April. And we know she's not wrong about that date because she wasn't working at Mr. Jackson's house in May. Remember she was fired? She wasn't there in May. So when she said when she started working, he was already working there, it had to be April. As we talked about earlier, there's evidence that Dr. Murray was already treating the Jackson family in California as of January 2009. So we've talked about most of the conduct between AEG Live and Dr. Murray. So what's left? Well, there were times where AEG Live staff attended meetings with Mr. Jackson where his doctor was present. That happened in June 2009. And there was one, where Dr. Murray called Randy Phillips. I'll be clear about that because they sometimes say it was the other way around. Where Dr. Murray called Randy Phillips. That's one call. And plaintiffs say these show that Dr. Murray was hired by AEG Live, that those actions show that. It doesn't add up. Having a meeting with someone doesn't mean you've hired them, I promise you. What about Dr. Murray having Mr. Ortega's cell phone number? Or getting involved in Mr. Jackson's rehearsal schedule? That doesn't prove he was hired by AEG Live. Mr. Jackson's personal assistant also got involved with Mr. Jackson's rehearsal schedule and had tore people's telephone numbers. So did his manager. That doesn't make them hired by AEG Live. So now we've talked about all the conduct between AEG Live and Dr. Murray. And all of it shows that there was no agreement between them. There was no contract. So how do plaintiffs try to get around that? They focus on actions and words by one party that the other didn't know about. Those hidden things that you can't look at. Remember, what you're looking for is what the parties communicated to each other. Hidden intentions may not be considered. You can't walk around telling everybody, you have a contract with me, but I don't know that, and therefore there is one. But plaintiffs are telling you to focus on things that Dr. Murray never knew about. They're telling you to focus on conduct that cannot create a contract. A perfect example of this is Mr. Phillips' statement that we hired him after Mr. Jackson had passed. Plaintiffs told you over and over again that this means there was a contract. That means there was an agreement. Now, how is that possible? Mr. Phillips' statement after Mr. Jackson's death doesn't create a contract before Mr. Jackson's death. You have to look at what the parties understood at the time, what actually happened. Look at what happened. Look at the evidence of what happened. And there's no evidence that Mr. Phillips ever discussed hiring Dr. Murray with Dr. Murray. You have no evidence of that at all. That wasn't conduct that Dr. Murray ever saw before Mr. Jackson's passing. That means it wasn't conduct that could have created a contract. Plaintiffs also argue Mr. Gonguera's email to Kenny Ortega on June 14, 2009, somehow that created a contract. You remember the email. You've seen it almost every day of this trial. They'll ask anyone about it. Now remember, only conduct between AEG Live and Dr. Murray can create a contract. It has to be conduct between them. This email is between Mr. Ortega and Mr. Gonguera. There's no evidence Mr. Gonguera ever told this to Dr. Murray. In fact, the only evidence at this trial, the only evidence, is that Mr. Gonguera's testimony on it. And he said he never had that conversation with Dr. Murray. You have to look at the actual evidence in the case. And plaintiffs haven't shown you a single piece of evidence that Mr. Gonguera ever spoke to Dr. Murray about who was paying his salary, other than in May when he told him that Michael Jackson was offering $150,000 per month. Whatever Mr. Gonguera was thinking about when he wrote this email, you can't consider his hidden intentions. If he never said that to Dr. Murray, it's not evidence of a contract. Period. End of story. Now, Mr. Panish has tried to attack Mr. Gonguera, mocking his memory, saying he doesn't remember anything, did that whole Brady Bunch thing. But that's just not true. Mr. Gonguera remembered all of the meetings he had. He remembered the meetings with Dr. Murray and all the conversations he had. He never didn't remember those. And he testified about all of those at Dr. Murray's criminal trial, at his deposition, and here in this trial. And he did so consistently. Because Mr. Gonguera remembers meetings. He remembers events that occur, places that he goes and talks to someone. He remembers what happens. What did Mr. Gonguera not remember? Think about this. Not what they tell you he didn't remember. It's fun to make fun of Mr. Gonguera. All right? Think about what actually happened. He didn't remember specific emails. He didn't deny them ever. He didn't say, I didn't write that. So he goes, you'd show him an email and say, oh, I don't remember that one. I don't remember the email. But then they'd ask questions about it. He said, well, I remember this happened and this happened and this happened. All he would say, truthfully, is I don't remember the email. At the time, if you remember, he stated that he was getting hundreds of emails a day. Remember, he was producing the show at that moment. Okay? They're going in less than a month to London. And he's getting hundreds of emails a day and producing the show. All right? He was getting thousands in this time period. And 4 years later, he didn't remember all of them word for word. At the time he wrote these emails, he had no idea that these thousands of emails would be picked over by Mr. Panish and his army of lawyers so they could tease out one to say that it says something it doesn't. So it's no surprise that he can't remember each one. And when he didn't remember something, you know what he did? He told the truth. He said, I don't remember that. And then went and explained if they asked him things in it. Well, what was going on with this, that, or the other at the time? He wasn't one of those witnesses who got up here and said, you know what I must have been saying? I'll tell you what it was. He didn't pretend he knew something he didn't. He would say, I don't remember that. But then you ask him questions and he would explain what he remembered. That's what telling the truth is. Not what you think occurred, what do you remember occurred? And when he didn't remember something, that's what he would say. I don't remember. He didn't make up an answer, even when it would have been much better for him to do so. Mr. Panish has done everything he can to make you doubt Mr. Gonguera's consistent testimony about his interactions with Dr. Murray. Because that's the focus here. It's your job, not Mr. Panish's, to assess Mr. Gonguera's credibility. And I ask you to remember what actually happened, not how he has persistently characterized it for 5 months. Remember, AEG Live doesn't have to prove there wasn't a contract here. That's not our burden. They are suing us. They have to prove there was a contract. They have to prove that Dr. Murray and AEG Live agreed to be bound without a written agreement. And they haven't done that. And remember, even if this agreement had been completed, even if it had been completed, it had been signed by Mr. Jackson, it was still Mr. Jackson hiring here, not AEG Live. So when you go look at Verdict Form 1, did AEG Live hire Dr. Conrad Murray? I think you have a multitude of reasons why the answer is no. And I think the biggest part of that is the actual evidence. Did they meet their burden of proof that it was AEG Live that hired Dr. Conrad Murray? I think that answer is no. And if you write no, you turn in your form, and your job's done. Now, as I told you, that's only the first element they have to prove. And so if you said yes, then we have to go on to the next one. And the next one is about competence and fitness. If you get to the next question, and I really hope you don't, the next thing plaintiffs have to prove is that Dr. Murray was not competent and fit for the job for which he was hired. Remember that part. Was he competent and fit for the job for which he was hired? This, too, is something they haven't proved because they can't. They keep telling you he wasn't fit and competent for the job Michael Jackson hired him for, that they didn't know about. But if they're the ones who hired him, he was competent and fit for that job. Look, nobody's claiming that Dr. Murray acted properly here. And we don't even know why. But we know that he gave Mr. Jackson propofol for sleep at home without proper equipment and monitoring. He wasn't an anesthesiologist. But what he did was far, far outside the planned job description and something no one would ever expect any doctor to do. You heard doctor after doctor repeat that. If you're not an anesthesiologist, you're not giving propofol. If you are an anesthesiologist, you're giving it properly. We heard doctor after doctor say they didn't even know what propofol was. So if you decided in Verdict Form 1 that AEG Live hired Dr. Murray, then the job for which he was hired by AEG
take Highway 172 over to 41 and rejoin Interstate 43 north of town. Above Green Bay in News Chopper 12, Matt Salemi, WISN 12 News.
admitted that. That's what he did in 4 states with no history of discipline and no malpractice. There was no malpractice complaints. And that's what he seems to have done competently for Mr. Jackson and for his 3 children from 2006 to 2009. Now, let's not lose sight of that fact. Everyone talks about what an amazing dad Mr. Jackson was. And we're not saying he wasn't. But Mr. Jackson thought enough of Dr. Murray to let him provide medical treatment to his own children. It's one of the reasons he was bringing them to London, we believed. And AEG believed that this doctor that Michael Jackson selected was competent and ethical. Nothing in Dr. Murray's job description, treating general medical needs, remotely suggests that Dr. Murray, who wasn't a trained anesthesiologist, would be administering a hospital-grade anesthetic in Mr. Jackson's bedroom behind locked doors at night to help him sleep. Nothing. Dr. Murray went way outside the scope of this job description and what he and Mr. Jackson decided to do with propofol. His conduct was so far beyond the pale that he was convicted of the crime of manslaughter. And if you believe Dr. Murray's job was to administer propofol, that just shows you even more that AEG Live wasn't the one who hired him. Because AEG Live had no idea. And the evidence proves AEG Live had absolutely no idea that Dr. Murray was administering propofol to Michael Jackson behind his locked bedroom doors. So if you think administering propofol was Dr. Murray's job, then you know that was a job that only Mr. Jackson could have hired him to do, not AEG Live. Everybody agrees. Dr. Murray did not treat Mr. Jackson properly on June 25th, 2009. That's not the issue. The question you have to decide is whether he was fit and competent for the job for which he was going to be hired. Not the secret job he was doing privately for Mr. Jackson behind locked doors at night, without AEG's knowledge and certainly without their input. So the answer to the second question, if you get there, is clearly no. He was not unfit or incompetent to perform the work for which he was hired. Because if he was hired by AEG, it wasn't for propofol. And if you answer no here, then again you enter a verdict in favor of AEG, and your job's done. Someone's waving at me. Are we approaching 12, Your Honor? The next section is quite large, so if we can stop at this point.
Fine.
Is that right?
Okay. Well, let's return to the courtroom at 1:30. Katherine Jackson versus AEG Live, BC 445597. Good afternoon, everybody. Counsel, you may continue with your closing argument.
Thank you, Your Honor. Thank you. So where we left off, I'm going through the verdict form. Question 1, question 2. Question 1, I believe the answer is no. AEG Live did not hire Dr. Conrad Murray. But if you say yes, we move on to question 2. It's question 2. I have to say then that I don't believe Dr. Conrad Murray was unfit for why AEG Live would have hired him. But if you say yes, well, we move on to question 3. And question 3 is about notice. If you get to the next question, you have to decide, did they prove notice? What did AEG Live know, and what should it have known? Plaintiffs must prove this. Was AEG Live on notice of Dr. Murray's unfitness? Once again, plaintiff's burden. They have to prove that AEG Live had notice. Now, notice is really important here because the law recognizes that it is not fair to find someone, a company, at fault for negligent hiring unless the company knew or should have known that the person it hired posed a risk to others. The company has to be on notice of that. Otherwise, it's not fair to hold them liable. Plaintiffs have to prove AEG knew or should have known that Dr. Murray, remember that's our focus, that Dr. Murray posed a risk to Mr. Jackson. And they haven't proved that. There's not a single piece of evidence in this case that anyone had any idea what Dr. Murray was doing. Whatever it was that he was doing. They didn't know how he was treating him. And they certainly didn't know anything about any risk that he was creating. Remember, this was in Michael Jackson's bedroom. I keep saying it. Bedroom, night, locked doors, security out front, gates. Nobody knew what was going on up there. There was no notice. Mr. Panish said yesterday that there were, and I'm going to quote this because I wrote it down, numerous occasions. That's what he said. There were numerous occasions where AEG Live knew that Dr. Murray was incompetent. But he didn't show you a single one. And that's because they can't. There's no evidence AEG Live had any idea about propofol. I'm going to try to tell you it's not about propofol. How's it not about propofol? They had to be on notice. Because certainly if they hired him, that being Dr. Murray, it wasn't for propofol. I'll say it again. There's no evidence AEG Live had any idea Dr. Murray was giving Mr. Jackson propofol to sleep. None. In fact, there's no evidence that AEG Live had noticed that Dr. Murray was doing anything other than providing for Mr. Jackson's general medical needs. None. So the question isn't what AEG Live knew. It can't be. The only question then here for you is, what should AEG Live have known? What should AEG Live have known? If you get this far in the verdict form, that's what you'll have to decide when you deliberate. Mr. Panish tried yesterday to say, well, AEG Live didn't have to know the specific risk. That's what he said. They didn't have to know the specific risk, just the particular risk. I thought about that when he said it. I was like, that sounds good. But then I thought about it a little bit more, and they're the same thing. Specific and particular mean the same thing. The law requires that AEG Live knew something specific, something particular about Dr. Murray that showed he was a risk to Mr. Jackson. It's about what AEG Live should have known about Dr. Conrad Murray. And plaintiffs can't show that AEG Live should have known that Dr. Murray posed a particular risk of harm to others. There was no way to know. So what do plaintiffs do? They make up things that AEG Live should have known. Things that they should have done. They focus on what AEG Live knew about Mr. Jackson, not what AEG Live knew about Dr. Murray. The world now knows what Mr. Jackson died of. He overdosed. He overdosed on propofol in his bedroom. Propofol that Dr. Murray gave him. But that's not the question you have to answer. You're not answering what we all now know. You have to decide what AEG Live should have known at the time about Dr. Conrad Murray. Put yourselves in AEG Live's shoes before Mr. Jackson passed. You have to decide based on what you've heard at this trial whether they should have known what was going on. And actually, Your Honor, it's not against the golden rule. The golden rule is to place yourself in the victim's place, not in the place of the person who actually had made a reasonable decision. They have to decide, is it reasonable? And that's what I'm telling them.
Either side. It's improper.
All right, sustained.
Thank you, Your Honor. Now, let's talk about a term plaintiffs use a lot here, red flags. They say based on these so-called red flags, AEG Live should have known Dr. Murray was likely to harm Mr. Jackson. But none of those flags point to Dr. Murray. None of them show he's a bad doctor. They may show Dr. Murray asked for a lot of money. They may show Mr. Jackson was sick on June 19th. But they don't show that Dr. Murray was harming Mr. Jackson, that he was dangerous to Mr. Jackson. And that's important. That's what's critical here. Plaintiffs need to prove that to win, and they haven't. Okay, let's talk a little bit again about Dr. Murray. What do we know, or what did we know, I should say, in 2009? The first thing we know was that Dr. Murray was his longtime doctor. They'd been treating Mr. Jackson and his family for years. And for that reason alone, AEG Live had no reason to doubt Dr. Murray. Mr. Jackson had already vetted him by selecting him as his family doctor. And he had been doing it for years, apparently without issue. Mr. Jackson liked Dr. Murray. Remember, he told Mr. Adams in Las Vegas that Dr. Murray was a very professional doctor. That's what he said. They're Mr. Jackson's words. And in February 2009, he told Dr. Slavitt that Dr. Murray was his personal physician who was caring for him regularly. Hard word. He told Dr. Slavitt that he liked Dr. Murray and was satisfied with the care that he was receiving from Dr. Murray. Plaintiffs, again, they try to distance themselves. You heard Mr. Panish say yesterday that Mr. Jackson only saw Dr. Murray 7 times from the beginning of 2006 to the beginning of 2009. Now, one might say that's regularly, but whether you do or not, you know what Mr. Jackson was saying, that it was his personal doctor. Plaintiffs don't want you to think that Mr. Jackson picked Dr. Murray, that he liked Dr. Murray, that Dr. Murray was his doctor for years. But those are the facts. That's the evidence. Just look at Mr. Jackson's medical records. They prove it. Not only was Dr. Murray Mr. Jackson's longtime doctor, there was nothing in his background, in Dr. Murray's background, that remotely suggested that he posed any risk of harming anyone. Remember, the idea behind negligent hiring is that companies aren't supposed to hire someone when something in their background shows that they are unfit or incompetent. There's nothing like that here. There was nothing to indicate there was any issue with Dr. Murray. In May 2009, back where you have to look, Dr. Murray was a licensed physician. He was licensed in 4 different states. That's the evidence. He had offices in several states. His license to practice medicine had never been suspended, and he had never been sued for malpractice. And in California, getting a license includes a fingerprint scan and a criminal background check. Dr. Murray passed that check in California and 3 other states. He had a valid medical license from the time he first started practicing through Mr. Jackson's passing. And that medical license was never suspended. Dr. Murray went to a good medical school. He had good residencies and good internships. And Dr. Murray was not a known rock doc. He didn't have a history of giving celebrities anything they wanted. He was a cardiologist. He was an internist. He had 4 practices. He treated pastors and members of local churches. He had never given anyone propofol before. He had never been accused of giving someone too much medication. Medication they didn't need. This isn't some situation like where someone hires a driver with a history of reckless driving or gives a guy with a history of violence access to weapons. Dr. Murray had no history of overdosing patients. None. No, he had a history of being a dedicated doctor, dedicated to his patients. That's what was knowable in 2009. And despite all of this, plaintiffs say AEG Live should have somehow known that Dr. Murray was going to give Michael Jackson an overdose of a drug they'd never heard of called propofol. But AEG Live did not have a crystal ball. So what does Mr. Panish do? They invent things that AEG Live should have done. They invent things that AEG Live should have seen. They make 2 main arguments. First, they say that AEG Live should have run a credit check. AEG Live should have figured out Dr. Murray was in debt. Then, it should have refused to advance him money if he went on tour. Second, Mr. Panish argues all the so-called red flags. All that talk about Mr. Jackson's health, the trouble at the front emails, all of that should have made AEG think Dr. Murray was harming Mr. Jackson, that he was going to kill him. Let's talk about each of those. Background check first. Heard a lot about it. Plaintiffs say AEG Live should have conducted a background check on Dr. Murray. And not just any background check, but an extensive check and an extensive investigation of his personal finances. And based on Dr. Murray's finances, AEG Live should have realized that he wasn't a good doctor. Members of the jury, that's another argument that does not make any sense. You heard from Ms. Seawright, their expert, Ms. Young, our expert, Mr. Trell, that background checks are generally not done on independent contractors. Any background check. And why? Because independent contractors are just that, independent. They are responsible for their own conduct. They aren't supervised. Plaintiffs talked earlier about supervision, but you heard from Mr. Trell and Ms. Young that independent contractors aren't supervised. And plaintiffs didn't give you any evidence showing otherwise. Plaintiffs showed you part of Mr. Trell's deposition yesterday, but they didn't show you all of it. And if they'd shown you the rest of it, you'd see that where Mr. Trell testified in no uncertain terms that AEG Live doesn't supervise independent contractors who provide personal services to artists. It doesn't do that in any way.
Mr. Trell, I have just a few follow-up questions. You had testified earlier that AEG Live sometimes supervises independent contractors, broadly speaking, depending on the circumstances. What about when an artist is engaged, when an independent contractor is engaged for a personal service to the artist, like hair or makeup? Do you supervise those people?
No.
So when you were talking about supervision, it was not people who provide personal services to artists?
No, I'm talking about the tour production generally, what you see on stage aspects of that tour production.
So would you supervise someone's makeup artist?
No, of course not.
You didn't see that part. And even for those who are supervised, as you saw Mr. Trell say yesterday, it's not about how they do the work, just checking at the very highest level whether it was done or not. That's what he said yesterday in the clip they showed you. That's because independent contractors are experts in their fields. Whether they're painters, plumbers, electricians, doctors, they have an expertise in their own field that the person who's hiring them does not have. You don't tell an electrician how to wire a house, or a plumber how to fix or run a pipe. And you certainly don't tell a doctor how to do their job. AEG Live was never going to be in a position to supervise Dr. Murray because they had no ability to tell him how to treat a patient. They didn't know how. Background checks are unheard of for doctors. Why? The California Medical Board does its own background checks on doctors, as I just told you. It does that before it licensed doctors. And Kathy Jury, AEG Live's doctor, she checked to make sure Dr. Murray was a licensed doctor. She testified to that. She checked. She checked him out. Now, she didn't do a credit check, but there was no reason to do so. Why not? Well, because any background check AEG Live did on Dr. Murray would have to be job-related. Do you remember the experts talking about that idea, job-related checks? A doctor's finances have absolutely nothing to do with whether a doctor is good at his job or not. Mr. Panish told you yesterday that all AEG Live needed was Dr. Murray's signature to run a credit check on him. That's not true. You heard Ms. Young talk about how credit checks must be related to the applicant's job. A company like AEG Live cannot legally run a credit check on someone unless it is necessary for their job. You get in a lot of trouble for that. Now think back to 2009 especially. Dr. Murray wasn't the only person in this country in financial trouble. He wasn't the only one with a house in foreclosure, and certainly not in Las Vegas. That's why most companies don't and aren't allowed to know every single detail of every financial detail of a person that they're thinking of hiring. You've heard testimony in this case that Stanford University, California Medical Board, they don't run those checks on doctors. But plaintiffs want you to hold AEG Live to a higher standard, one that doesn't apply to others. But the standard you must apply, that's what would a reasonable person do? You heard that yesterday. And the truth is, any reasonable person would assume that a doctor is going to act ethically. even if they're in debt. That's what they promise to do. That's their Hippocratic oath. Doctors swear in that oath to do no harm and to put patients first. And AEG Live had every right to expect that Dr. Murray would follow his Hippocratic oath. One second. And there's an instruction of law that you received on this as well. You were instructed that, quote, every person has a right to expect that every other person will use reasonable care. AEG Live had a right to expect Dr. Murray to do just like that, like all doctors. They thought he would not violate the law or his Hippocratic oath, and they had a right to expect that. Remember, he had never harmed a patient before. Plaintiffs have to prove that AEG Live knew or should have known that Dr. Murray might nonetheless harm Mr. Jackson. Showing that Dr. Murray was in debt just doesn't cut that. Nothing in Dr. Murray's background suggests that he would be dangerous. Nothing. Now, let's go to the red flags. One of those is past drug use. Plaintiffs say that Mr. Gongaware, Paul Gongaware, knew back in 1993 what the whole world knew, that Mr. Jackson had a problem with painkillers. Plaintiffs claim this means that AEG Live should have immediately been suspicious when Mr. Jackson told AEG that he was bringing his doctor on tour 2 decades later. That prior drug use says nothing about Dr. Murray. That's not evidence that AEG Live knew that Dr. Murray was a problem, that they knew what Dr. Murray was doing. Remember, Dr. Murray didn't prescribe a single opiate painkiller. Remember that. He didn't. All the evidence shows Mr. Gongaware knew in 1993 what the whole world knew, that Mr. Jackson had a problem with painkillers and that he went out and got help for that problem. He'd gone into rehab. You heard from Mr. Gongaware and from John Meglin, the 2 AEG Live executives who first met with Mr. Jackson in 2007. Mr. Gongaware didn't see any signs of drug use from Michael Jackson during those negotiations in 2007 or in 2008 or in 2009. Neither did Mr. Meglin. And Mr. Jackson's security officer, his security officer, Mr. LaPeroux, do you remember him? He backed Mr. Gongaware and Mr. Meglin up. Mr. Jackson seemed totally clean during those negotiations. He was there. Remember, he brought him to and from? He looked great, sounded great, was clear-eyed, he was focused. That's Mr. Jackson's security guard saying that. The same one you remember who years before recalled the slurred phone calls late at night? He knew what to look for. The same one who revived Mr. Jackson from an apparent overdose after his children called 911 at Disney World. Do you remember him? He's the one who later now brought Mr. Jackson to and from these meetings, and he said Mr. Jackson looked great. And that's what AEG Live saw as well. Now, February 2009, after the deal with Mr. Jackson was signed, Mr. Jackson passed a physical. You remember it was with flying colors? That was the quote. That was Dr. Slavitt again. He was doing the physical so Mr. Jackson and AEG Live together could get insurance for the tour. But Mr. Jackson didn't tell Dr. Slavitt anything about painkillers or insomnia, stuff he'd been struggling with for decades. Dr. Slavitt could only make a decision based on what he was told, on what he saw, on the healthy individual standing in front of him. So he issued a report giving Mr. Jackson a clean bill of health. As a result, AEG Live believed Mr. Jackson was perfectly healthy. He had put those days of drug use behind him from 2 decades before. When he was younger, that was gone. He was now a 50-year-old man with kids ready to return to the world stage. He was ready for his redemption. And that's what AEG Live saw. Perhaps more important, AEG Live heard from Mr. Jackson himself that he was healthy, that he was ready to perform. Mr. Jackson told AEG Live that he was healthy, that there were no health concerns that would interfere with his ability to tour. Now, how do we know that? Because that's the promise he made in his contract with AEG Live. That's what Mr. Jackson told AEG Live. And that's what AEG Live believed. It's certainly what they saw. And you can see it right there for yourself. That's Exhibit 66, page 10. At the end of the day, what plaintiffs are saying is that no reasonable person could possibly believe Mr. Jackson was telling the truth. When Mr. Jackson said he was healthy enough to do the tour, AEG Live apparently should have assumed he was lying. Because of a painkiller problem 2 decades before, for which he had gone to rehab? Members of the jury, that also doesn't make sense. A reasonable person in Mr. Gongaware's position would believe exactly what Mr. Gongaware did believe in 2009, that Mr. Jackson was clean, sober, and honest. By all appearances, that was true. Now, the $5 million. Let's talk about that for a moment, this red flag, which is that Dr. Murray first asked Paul Gongaware for a lot of money, $5 million to go on tour with Mr. Jackson. Now, they say that because Dr. Murray asked for so much money, AEG Live should have realized instantly that there was something suspicious about that. He must be a bad doctor. Asking for a large amount of money does not make someone a bad doctor or a bad person. Maybe a bad negotiator, but not a bad doctor. And one might even argue not a bad negotiator. Just because someone asks for large money, that certainly doesn't mean they're going to go on to commit the crime of manslaughter. Think about that. Does that make sense? This is the king of pop we're talking about here. They've said it, I don't know how many times yesterday. Every single person AEG Live negotiated a contract for was asking for top dollar. You saw that with Kenny Ortega, with Travis Payne, with Karen Fay. AEG Live had no reason to think twice about a big initial ask. It happened all the time. It was not unusual. You start high, you negotiate down. Mr. Gongaware testified to that himself. He said it's not unusual in his business to, quote, see people asking for way too much money, end quote. The fact that Dr. Murray asked for $5 million doesn't say anything about what Dr. Murray did behind closed doors. All right, the fact of a doctor. That's the next red flag. Plaintiffs have argued that the mere fact that Mr. Jackson asked for a doctor should have caused AEG Live concern because it was an unusual request. Remember, all these are about Mr. Jackson. Now, you don't see anybody else saying that. You see plaintiffs' counsel saying that. The witnesses didn't say it, and the evidence doesn't support it. Mr. Panish said yesterday that Mr. Berman said it was highly unusual to bring a doctor on tour. Mr. Berman wouldn't know. Remember, he's a record executive. That's what he did for a living. He never once in his whole life worked on a tour. He admitted that. But let's look at the evidence from people who actually have experience on the tours. Evidence that actually was presented at this trial. Stacy Walker. She was a dancer, choreographer. You remember her? She came in. We had to bring her in a little bit early because they were going on tour. She'd done this for 20 years in this industry, and she testified that it's not rare for doctors to go on tours. Marty Hom, again, an expert with years of experience in the touring industry. He also testified that doctors go on tours with artists. Sean Trell identified that both Celine Dion and the Rolling Stones, 2 other big artists AEG works with, they both brought doctors on tour. John Meglin also testified that John Denver brought a doctor on tour. Some of you will know who that is. Now, Dr. Metzger, he testified. You heard him. That was Mr. Jackson's own physician for many years, and he testified that he went on tour with Mr. Jackson in 1996 and apparently did nothing inappropriate. The fact that Mr. Jackson asked for Dr. Murray says nothing about what Dr. Murray was doing to Mr. Jackson behind locked bedroom doors. Weight. Oh my, we heard a lot about Mr. Jackson's weight. A person's weight, whether over or under what it should be, doesn't mean they have a bad doctor, especially in this case. You heard Dr. Metzger identify that it was common for Mr. Jackson to lose 7 to 8 pounds a night when he was performing. And you heard similar testimony from Karen Fay, from Debbie Rowe. Let's look at the facts here, the facts on Mr. Jackson's weight. First, according to the coroner, he wasn't underweight when he died. He was 136 pounds. And as the coroner also testified, Mr. Jackson's body mass index, when we talked about BMIs, that was in the normal range. His weight was normal. It was 136 pounds. And that was about what Mr. Jackson had weighed his entire adult life. How do we know that? We looked at all the medical records. And that's what we saw. It hardly fluctuated. But Mr. Panish says he looks really thin in this one picture from his dressing room. So let's look at that picture. Again, every witness was shown it. The biggest problem with this picture is that it is from Mr. Jackson's dressing room. We don't have to talk about everybody can take a bad picture. It depends on the angle. I won't go through all those things. Let's just go through the simple fact of it. This is from his dressing room. Nobody outside that dressing room ever saw Mr. Jackson in a thin T-shirt. Look at what everyone else saw. This is what everyone else saw. This is Mr. Jackson 4 days later on June 23rd. And you have to look at what people actually knew. What could they see? People weren't going into Mr. Jackson's dressing room from AEG Live. You have no evidence that they did. Remember at rehearsals, he wore jackets, poofy shirts, all kinds of layers? And Kenny Ortega was there. Mr. Ortega testified that he never saw Michael Jackson look as thin as he appears to look in this picture. He said he never saw him like that. He was there every day. He never saw him like that because he wasn't back in the dressing room. And Karen Fay testified that it might have been difficult for others on the tour who didn't see Mr. Jackson in his dressing room. It would be difficult for them to notice the weight loss. Exactly. Once again, plaintiffs want AEG Live to be aware of what Mr. Jackson did in his bedroom at night and what he did when he was getting changed. They didn't know that, nor should they. The whole thinness thing is just a big distraction. As the coroner told you, Mr. Jackson did not die because he was too thin. And weight loss is not the sort of thing that would lead any reasonable person to conclude that Mr. Jackson's doctor was administering an anesthesia in his bedroom at night. They don't connect up. Mr. Jackson's weight says nothing about what Dr. Murray was doing behind Mr. Jackson's locked bedroom doors. Declining health. I keep talking about the supposed declining health, and that somehow was a red flag that identified Dr. Conrad Murray. Supposedly, he had been in decline for weeks or months, and that everyone should have seen it. That's their claim. That's simply not true. And even if it was, it doesn't mean that Dr. Murray was the cause. People get sick and they get tired. That doesn't mean their doctors are unfit or incompetent. It doesn't mean their doctors are the cause of that. Think about that. When you see someone ill and there's a problem, you think, oh, bad doctor. That's not how it works. Remember, as the judge instructed you, a person is not negligent just because they don't take affirmative steps to save someone. The only way that Mr. Jackson's health matters is if you also believe that something about Mr. Jackson's health should have put AEG Live on notice that Dr. Murray posed a danger to Mr. Jackson and others. And the evidence just doesn't support that. Let's talk about the actual evidence of this time period. Remember they talk about 8 weeks of decline? Let's talk about it. The only evidence plaintiffs have for their claim that Mr. Jackson was in decline for 8 weeks is one email from a production manager, Bugsy Hugdahl. That was on June 19th, 2009. It's part of all those trouble with the front emails. Did Mr. Hugdahl really think Mr. Jackson was declining over 8 weeks? Well, let's look at what he was saying at the time. Because 5 days before this email, 5 days, There was the one that Kenny Ortega sent to Mr. Gongaware on June 14th. We saw it earlier. We saw it yesterday. The one where he raised some concerns that Mr. Jackson might need a physical therapist or a nutritionist. Mr. Gongaware forwarded that email to Mr. Hugdahl. And it was also forwarded to Travis Payne, as you may recall. And remember their responses. Mr. Payne suggested a massage chair for Mr. Jackson. That's what Mr. Payne said. Mr. Hugdahl suggested a cheeseburger. Remember he said he just needs a cheeseburger and some Mozart brats? Remember when that was said? Now, if Mr. Hugdahl was really serious, really concerned about Mr. Jackson's health over the prior 8 weeks, he wouldn't have made a joke about his weight just a few days before. Remember, everyone who has testified says Mr. Hugdahl was a caring person who wouldn't have joked if he thought Mr. Jackson was really in trouble. The fact is that nobody had serious concerns about Mr. Jackson at this point in time. Do you think Mr. Payne, you remember Travis Payne, choreographer, again, he came in a bit early too because they were going to go away. The fact is he came in and he was working with Mr. Jackson every day at his house. Remember that testimony? To be working at the house? So he's seeing him all this time. Do you think he would have suggested a massage chair at that time period if everyone was concerned about Mr. Jackson's declining health over the past 8 weeks? That doesn't make any sense. It's easy to look back with what we now know and try to connect dots. That's that hindsight 2020 thing that we talked about. Remember what Mr. Payne said about that. But you have to consider what people knew at the time, not how they look back at it. And remember at the time, Travis Payne was with Mr. Jackson basically every day and had been for 8 weeks. And at the time, he never had any inkling about anything being wrong. Nothing. And if he didn't, how should AEG Live? He was there every day. They weren't. If he didn't have an inkling, how could they? They only visited occasion to rehearsals. You heard that testimony. It doesn't make sense. There's no red flag there. So let's look at the timeline of the supposed 8-week decline. 8 weeks before would have been late April, right? You heard from Dr. Metzger. You heard from Dr. Lee, 2 healthcare professionals, that Mr. Jackson appeared completely healthy in April. And everyone working on the tour said the same thing. The same is true for May. Mr. LaPeroux testified that Mr. Jackson looked happy. He looked good at his parents' anniversary on May 14th. He said Mr. Jackson was laughing and in a good mood. You remember, Mr. LaPeroux knew what it looked like when Mr. Jackson wasn't in that state. He saw him on the 14th, took him aside, Mr. Jackson aside to a room during his parents' anniversary party. They asked how he looked. He said he looked great. He said Mr. Jackson laughing and in a good mood. Alif Sankey, the assistant choreographer on the show, she said Mr. Jackson had a magical performance on June 6th. And she said Mr. Jackson was very excited and engaged before that. Even Ms. Fay, the makeup artist, she didn't become truly concerned that something might be wrong with Mr. Jackson until the last week of his life. That's well into June. The only thing anyone noticed in May was that sometimes Mr. Jackson was a little groggy after visits to his dermatologist, Dr. Klein. For skin care, cosmetic procedures, that didn't raise red flags because he seemed to be getting legitimate treatment from Dr. Klein. It certainly didn't raise red flags about Dr. Murray. Nobody was seriously concerned about Mr. Jackson's health in May. June. Let's look at Mr. Jackson in June. I'm going to show you this. You saw a trial, Pam?
What is that? One more time. 6, 7, 8.
That's June. June 5th, 2009. He looks great. He looks incredible. You saw the whole thing. And if you want to go back and see the whole thing, you absolutely can do so. It's Exhibit 12927. There's nothing that remotely suggests that Mr. Jackson was in trouble. and certainly nothing suggests that he was being harmed by his long-term personal physician. Because remember, you're being asked about what AEG Live knew about Dr. Murray. It wasn't until around the end of the second week of June that some people started to have some concerns, around June 14th. But what were those concerns? And that's important, because those concerns were very specific. Mr. Ortega was concerned about Mr. Jackson's preparedness for the shows, specifically that he might not be in good enough physical shape or might be suffering from joint pain. He was also concerned about Mr. Jackson maybe not eating enough to keep up with the workouts. That's why he suggested on June 14th, 2009, that Mr. Gongaware, without invading MJ's privacy, remember that? See if Mr. Jackson could use a physical therapist or a nutritionist. In the email we talked about earlier, Mr. Gongaware responded that he and Mr. DeLeo, Mr. Jackson's manager, were working on setting up a meeting with Mr. Jackson's doctor per Mr. Ortega's suggestion. And Mr. Ortega's response shows that he understood what Mr. Gongaware meant at the time. And think back to what we talked about at trial. Would they be asking to see him if they'd hired him? Remember all of those things? Remember the Ray line with stylist? Go back and look at that exchange. The concern there was very specific. Preparedness. Plaintiffs want you to believe that Mr. Gongaware wanted Mr. Jackson to perform at all costs and was going to pressure Dr. Murray to ensure that he did so. But nothing in this email even slightly suggests that. Go look at the whole exchange. Put it in the context it needs to be put in. And remember, at the same time he sent this email, Mr. Gongaware also started asking around whether anyone could recommend a good physical therapist or nutritionist for Mr. Jackson. You saw the evidence of that too. Mr. Gongaware wanted nothing other than to help Mr. Jackson any way he could. He wanted Mr. Jackson's comeback to be a success. And you heard that Mr. DeLeo, Mr. Jackson's manager, set up meetings with himself, Mr. Jackson, Dr. Murray, Paul Gongaware, and Mr. Phillips to address these exact issues: nutrition, stamina, physical therapy. And Dr. Murray assured everyone that Mr. Jackson was fine, doing well. He was drinking those special shakes to gain weight. That was that meeting. And don't forget, this is the first time anyone at AEG Live had met Dr. Murray in person. Plaintiffs try to paint a dark picture of this meeting. Ms. Chase says Dr. Murray was upset and said, "I can't handle this shit." And he runs out, "I can't handle this shit." Well, Ms. Chase, of course, didn't say any of this until after plaintiff's lawyer hired her and represented her at her deposition. But even if her testimony is completely accurate, it simply doesn't prove what plaintiffs suggest. Maybe Dr. Murray was stressed about the fact that he had just spent a lengthy meeting lying to AEG Live, and Michael Jackson's manager about what was actually going on. Maybe that's what had happened. Or maybe Dr. Murray was upset because he had realized that he was working for an addict, and he didn't know that before. So now he's in over his head. We don't know what he was thinking. But Mr. Panish wants you to speculate that it must be something bad. Why else would he have run out and said that? But he doesn't say what. What was the bad thing that he was running out from? What was the bad thing that he was thinking and that resulted in him saying that? What happened at that meeting? Listen, speculation is not evidence. Certainly whatever happened didn't make Ms. Chase suspicious that Dr. Murray was harming Mr. Jackson. She didn't get suspicious from it. She's the one who saw it. She testified that she liked Dr. Murray and believed he was a good doctor taking good care of Mr. Jackson. That was her testimony, the person who saw it. If it didn't make Ms. Chase, who was there at Carrollwood with him, and there with him and Mr. Jackson every day, if it didn't make her suspicious of Dr. Murray, why would it make AEG Live suspicious of him? Remember, it is plaintiff's burden to prove that AEG Live should have known that Dr. Murray was unfit or incompetent, and that he was likely to harm Mr. Jackson. The question you have to answer here is whether plaintiffs have proved that. Now let's get back to actual evidence. There's no evidence that has been presented to you at this trial that Mr. Jackson suffered from anything other than weight loss, tiredness, muscle soreness, and nervousness before June 19th. There's no evidence to the contrary. That's all you've heard prior to June 19th. These symptoms wouldn't make anyone think Dr. Murray was giving anesthesia to Mr. Jackson in his bedroom for sleep. The much more reasonable explanation for those symptoms, the one everyone believed at the time, was that a 50-year-old man who hadn't performed in a decade was tired, out of shape, and very nervous. That's what they understood at the time, and it makes sense. Mr. Jackson's symptoms say nothing about what Dr. Murray was doing in Mr. Jackson's locked bedroom. Now, trouble at the front. Let's deal with those emails. You remember that's on June 19th, and remember, as was often the case, this is a day where no AEG Live employee was actually present at rehearsal. Okay, so remember that. They weren't there. Paul Gongor wasn't there. Randy Phillips wasn't there. And Mr. Jackson was ill. He was chilled. He had the shakes. People were concerned. Kenny Ortega was very concerned. Bugsy Hugdahl was concerned. And they emailed Mr. Phillips and Mr. Gongaware about their concerns. They weren't there to see them. These people were concerned and they emailed them. Now, plaintiffs have made a lot of the emails that night. Trouble at the front thread. They showed them yesterday, and I encourage you to read the whole chain, not just a handful of words that have been the focus of plaintiff's case. Put it in context. Go read all of them. And remember, it's one of those chains that then breaks off like a tree into other chains that are people reading. Look at the chains together and see what actually happened. None of these emails, not one, show AEG Live had reason to know Dr. Murray was the source of Mr. Jackson's problem that evening. No one knew what the problem was. That's what everyone said. You see it in the emails. You see it in their testimony at trial. They didn't know what was wrong. Was it chemical or physiological? Was Mr. Jackson doing this to himself? That's what Karen Fay suspected. Was he having psychiatric problems? Was it the flu? Was it one of his cosmetic treatments from Dr. Klein? Everyone agrees Mr. Jackson was sick on June 19th, but no one knew why. You have to go back to what they knew on June 19th, 2009. Nor would it be something any layperson could possibly figure out. In fact, even the experts disagree to this day about what those symptoms were. Think about it. You've been sitting as jurors in this case 5 months? Testimony for 4? Is that right? Do you know today what was wrong with Mr. Jackson on June 19th? Do you know? Did someone tell you? No, because no one knows. And none of these symptoms pointed to Dr. Murray, that he was the reason Mr. Jackson was ill. Remember, as far as anyone at AEG Live knew, Dr. Murray had been Mr. Jackson's doctor for years. Through all those great negotiations in Las Vegas, through the signing of the tour agreement, through the whole period, Mr. Jackson being ill on one night, doesn't suddenly have everybody pointing their fingers at Dr. Murray. We can do that in retrospect, but at the time, there was no reason to do that. Not knowing what is wrong with Mr. Jackson says nothing about what Dr. Murray was doing with Mr. Jackson in his locked bedroom. Plaintiffs spent a lot of time on June 19th. To be frank with you, I would say I believe it's their whole case. But it's not the whole story. Because what happened after June 19th is very, very important. Because Mr. Jackson continued to conceal what was really going on. He continued to tell everyone he was fine because he wanted this tour. It was his tour, his dream, and his choice. Let's look at one of Mr. Ortega's emails further down the chain. And this is Exhibit 307. Mr. Ortega says Mr. Jackson, quote, really wants this, end quote. And, quote, it would shatter him, break his heart if we pulled the plug, end quote. So what did AEG Live do? They did what any reasonable person in their position would do. They let Mr. Jackson's management team know what was going on. Remember, Mr. Jackson had a whole team of advisors. They were his team. And they all received these emails. And then Mr. Phillips personally met with Mr. Jackson to see if he was okay. Remember, there's trouble. The front emails didn't end with AEG when it was sent to them. They then sent it to all of his advisors. And the next day, at the request of Mr. Jackson's manager, Mr. Phillips and Mr. Ortega met with Mr. Jackson and his doctor. They hadn't seen Mr. Jackson yet after this episode. It was, 12 hours later, 14 hours later? And both Mr. Jackson and his doctor told Mr. Phillips and told Mr. Ortega that Mr. Jackson was fine. Dr. Murray assured them that he had Mr. Jackson's health under control. He said Mr. Ortega should direct the show and leave Mr. Jackson's health to him. Remember, stay in your lane. Mr. Panish said yesterday that AEG Live said that to Dr. Murray. That's not true. Stay in your lane is what Dr. Murray said to Mr. Ortega and to Mr. Phillips. That's what the testimony is. Go look. And let's talk for a minute about what Mr. Jackson had to say, because Mr. Jackson was there. They went to see how he was doing and if he was okay. Mr. Jackson, because Mr. Panish said yesterday it was Mr. Phillips who reassured Mr. Ortega, I want you to actually look at what happened. Mr. Jackson, a 50-year-old man, told his business partners he was fine. He told them he was okay. He was ready to take the reins on the tour. And he told Mr. Ortega not to be afraid. There was nothing to worry about. Those were Mr. Jackson's words in that meeting. And Dr. Murray, Mr. Jackson's long-term personal physician, backed him up. He said Mr. Jackson was fine. Whatever had happened the night before, he was better. The tour staff should stop trying to act like doctors and leave Mr. Jackson's health to them. Mr. Panish likes to say AEG Live should have done something more. But what more could a reasonable person do when a grown man says he's fine and doesn't need help? On June 20th, Mr. Jackson was much better. That next day, he was much better. He was calm, he was clear, he was normal. And his doctor said he was fine. That's the testimony. And so did Mr. Jackson. At this point, there was nothing more for Mr. Ortega or Mr. Phillips to do. Now, of course, before the meeting, as you all know, Dr. Murray also called Mr. Phillips. Dr. Murray called Mr. Phillips, not the other way around, and they spoke on the phone for about 20 minutes. It's on the way to the meeting. Plaintiffs try to imply that there was something bad or improper about this call. But there is zero evidence, again, to support that. Zero. And remember, speculation is not evidence. Let's look at the only actual evidence of what happened on that call. The email that Mr. Phillips wrote right after it ended. Dr. Murray told Mr. Phillips the same thing he told Dr. Ortega later that same day. He said the same thing. Don't be an amateur physician or psychiatrist. Michael Jackson is fine. He is physically and mentally equipped to perform. Dr. Murray assured Mr. Phillips that he was at the house with Mr. Jackson and that Mr. Jackson was fine. That's what happened during that call. Not some sinister meeting between Dr. Murray and Randy Phillips, which is what they'd like you to believe. And what about this part that Mr. Panish loves to focus on? I'm gaining immense respect for Dr. Murray, and he is totally unbiased and ethical. That shows that Dr. Murray had completely deceived Mr. Phillips. For that is what Mr. Phillips believed on June 20th, 2009. And that's what you're supposed to look to. He had deceived him in the same way he had deceived Kai Chase, apparently, who was in the house every day. The same way that he had deceived Mr. Jackson's son, Prince, who said the same thing. And the "we check everyone out," yesterday they said that was a lie. They love to claim that Mr. Phillips was lying here. Usually they'll mock how he speaks. Okay? Mr. Phillips is talking about his conversation with Kathy Jory, and you know it. She said so. They discussed that Dr. Murray was successful. that he had licenses and practices in multiple states. She is AEG Live's outside counsel. Mr. Panish spent a lot of time in closing attacking Mr. Phillips, doing the voices, mocking his memory. Until on a break, he came back and said, oh, I shouldn't have done that. To try to paint Mr. Phillips as a liar. But at his deposition, plaintiffs played a game of gotcha. They showed him 4-year-old emails in a context. They confused him. And even when he explained himself at the deposition, he'd later say, well, wait, now I can put this in context. They showed the other emails. They then came back here nonetheless and just played the confused answer parts in trial instead of the clear ones. You saw that. Remember that line where Mr. Phillips asked if Mr. Panish wanted the truth or his testimony? Do you remember that? That's what they did yesterday. It's because he had made a mistake in his testimony. He owned up to it, and he tried to explain it. But Mr. Panish didn't want to hear that. He wanted him to repeat his mistaken answer so he could contradict it with the truth, or tell the truth so he could contradict it with the mistaken testimony. A game of gotcha, with the truth being the loser. That's not a search for the truth. It's up to you to determine whether to believe Mr. Phillips or not. That's your decision. But I want you to think about whether his testimony ever changed on the points that are most important here. Mr. Jackson choosing Dr. Murray and determining he came on that and demanding that he come on tour, did he ever change that testimony? No. Mr. Jackson reassuring Mr. Phillips and Mr. Ortega on June 20th? No. Mr. Jackson's amazing performances on June 23rd and 24th? Same. Because that's consistent. It's the same thing he said in June 2009. Remember the rest of that video plaintiffs often like to show a few seconds of, that we hired him one? Remember we then came back and said, look at everything he said up to that point? We showed you the whole thing. And Mr. Phillips said all the same things about Dr. Murray just 1 week after Mr. Jackson's death. And he did it in this court and at his deposition. And it's also the same story in his emails at the time. Look and see. The takeaway from the trouble with the front emails is that no one knew what was going on. That brings us to the last part of that June story, the 8-week decline. The part Mr. Panish never talks about. Never during trial. Not yesterday. Because it shows how much plaintiff's case doesn't make sense. After being sick on June 19th, Mr. Jackson took a couple of days to rest. He canceled a session with Mr. Payne, and he came back on June 23rd, 2009, and gave the best performance of the entire rehearsal period. And he did it again on June 24th. Let's talk about those rehearsals. The last times Mr. Phillips and Mr. Gongleware saw Mr. Jackson. Let's look at the clip of the This Is It movie from June 23rd. In fact, I encourage you to watch the movie. It's Exhibit 12-927. I'll say it again. Exhibit 12-927. It's an exhibit. Watch it. Watch the whole movie. You can ask to view it. You can watch the rehearsals. And you can see what everyone saw at the time. Take 2 hours. Take a look. See what you think. Yesterday they played countless clips of Mr. Jackson from the 60s, from the 70s, from the 80s, from the 90s. Why don't you go look at the movie and see how he looked in 2009, particularly on June 23rd and June 24th. Exhibit 12-927. Anyway, right now I want to show you a clip from the 23rd. Watch the red shirt.
the greatest demonstration for freedom in the history of our nation. Create your history. Some things in life they just don't want to see, but it's hard to lose the wasn't in it. Keep walking like we know it. All I want to say is that they don't really care about us. It's giving fire. All I want to say is that they don't really care about us. Can't do it all. All I want to say is that they don't really care about us. That's the feeling. All I want to say is that they don't really care about us.
Hold for applause, slow umbrella fade out.
That's the 23rd. Now, I went through the movie to choose that clip because if you look at the movie, what you'll see is there are clips from different days that will show an entire song. That's why I chose that one to show you. That one uses just him that day. I wanted to show the red shirt because if you go back and look at the movie, look for the red shirt. When you see the red shirt, that's what he was wearing on the 23rd. He put on different jackets through the rehearsal. The red shirt stays the same. If you look at the movie and you see the red shirt, that's on the 23rd. I think there are about 6 different jacket changes during that, okay? And that's because he rehearsed for hours. That's after June 19th. That's 3 days after that meeting on June 20th. Now remember, the footage wasn't filmed for a movie. That wasn't the intention. Remember, it was a rehearsal. It was a rehearsal. They wanted to be able to show, like what Kenny Ortega said, they wanted to show you what the show was going to be like. Go see how he was at rehearsal. Not bad. He's older than me. Sometimes Mr. Jackson's microphone was turned on. Sometimes it's turned off. You'll see. And in that clip we just saw, you can see that sometimes he's singing, and sometimes he's just dancing with the background track. You'll see that throughout. Let's take one more look at another short clip, also from June 23rd, where you can see Mr. Jackson singing live. Same shirt.
Just trying to conserve my throat, please, so understand. I will be, I will be, I will be, I will be, I will be.
Mr. Panish tries to make it seem like a big deal that Mr. Jackson couldn't sing fast-paced numbers and dance at the same time. But Mr. Payne told you he never did that in all his prior tours. And you can see that from the movies plaintiffs have shown you. What's important here is the testimony and that there's no difference in how Mr. Jackson looks here or how he acts. And that's what matters. That's what's important here. Because how Mr. Jackson looks in the movie is how he looked to people at rehearsal on those nights. That's what they saw. So again, this is Mr. Jackson just days after he was ill on June 19th. We asked Mr. Ortega about that. He said it was a miracle. Mr. Jackson had had a metamorphosis, that he was fired up, that he was in charge. Remember Stacey Walker? She was so excited from that rehearsal that she called her mom and told her to go buy a ticket to come see opening night. It was going to be amazing. That rehearsal. The change was so great that Mr. Ortega testified that he started to doubt his own memory of what had happened on June 19th. And remember, Mr. Ortega is not the only one who says this. Even Karen Faye says Mr. Jackson was not like he was on June 19th on any other day of rehearsals. Same with Alif Sankey, same with Travis Payne. June 19th was an anomaly. There was no day like it before or after. Remember, by the way, Mr. Ortega testified that by June 23rd, he wasn't worried about Dr. Murray anymore. Not at all. And remember, he also testified that he never told anyone at AEG Live that he had ever had any worry about Dr. Murray.
Mr. Putnam, 5 minutes before we take our break.
Yes, Your Honor.
Okay.
Scared me. Let's look again at how Mr. Jackson looked on the 23rd. Do we have time for this clip, Jess? No? Okay. And I'm going to skip on so I don't run out of time at the end. This is another one of his brilliant performances. Go look at the movie. And it wasn't a one-time thing. He did it again the next night. And he did it again and again. 12 hours after this performance, Mr. Jackson was dead. Pam? I'm trying.
What have we done to the world? Look what we've done. What about all the peace that you pledged your only son? What about flowering fields? Is there a time? What about all the dreams that you said was yours and mine? Did you ever stop to notice all the children dead from war? Did you ever stop to notice this crying earth, this weeping shore? I used to dream, I used to glance beyond the stars. Now I don't know where we are, although I know
All right, we'll take a break in a moment, but I want to say 12 hours later, Mr. Jackson would be dead.
Okay, I'll see you in 15 minutes. Katherine Jackson versus AEG Live, BC 445597. You may continue.
Showed you the 23rd, showed the 24th. Who could have known otherwise? And remember what plaintiffs have to prove here. They have to prove to you that AEG Live should have known that Dr. Murray was unfit and incompetent, and that his unfitness or incompetence created a particular risk to others, specifically Mr. Jackson. Nobody could have known that from the facts plaintiffs have presented here. Weight loss, flu symptoms, debt, a request for a big paycheck from the king of pop, illness one evening. None of these are facts that would have made a reasonable concert promoter second guess an artist's choice of who his personal doctor should be. Certainly none of them put AEG Live on notice that Dr. Murray was unfit or incompetent, and that it was dangerous for him to treat Mr. Jackson. Remember, he had been treating Mr. Jackson for 3 years. If you reach this question, members of the jury, you please use your common sense. Hindsight is 20/20, but think about what a reasonable person would have thought at the time. Remember, no one in 2009 thought Dr. Murray was harming Mr. Jackson. No one. Dr. Murray and Mr. Jackson fooled everyone. They want you to blame AEG Live for failing to see something that no one else saw. They want to blame you for something they didn't see. That's not how the law works. And that's certainly not a search for the truth. Now, going on the verdict form, we're now at causation. It's question 5. Now, again, that's only if you get that far. And plaintiffs have, again, to prove this. They have to prove causation. Was AEG Live's conduct with regard to Dr. Murray a substantial factor in causing Mr. Jackson's death? There was an instruction on this. This substantial factor language is important. As the judge instructed you, quote, conduct is not a substantial factor in causing harm if the same harm would have occurred without that conduct. Plaintiffs want you to believe that Mr. Jackson wouldn't have gotten propofol absent AEG Live's interactions with Dr. Murray. In fact, Mr. Panish told you in his opening statement, and again yesterday, that every doctor other than Dr. Murray said no. That's what he said. It's not the case. Mr. Jackson had abused this drug since the 90s. You saw for decades that he would seek out propofol for even the most mundane procedures, like Botox. Going for a little Botox, he'd get propofol, things that people get from major surgery. And he used it in Germany to sleep on a history tour. We know that. Twice that Debbie Rowe knows of, but lots more than that, according to what Mr. Jackson, what he himself told Dr. Van Valen, his words. Mr. Jackson chose to ask for propofol many times after that. Now, it's important to remember that no one has said Mr. Jackson was addicted to propofol. No one has said that. He liked it. He pursued it. He got it. But there's no evidence that he was physically or mentally unable to stop using it if he chose to do so. But he didn't. He never chose to stop. It goes back to what Karen Fay said. Mr. Jackson wasn't the sort of man who took no for an answer. He wanted the doctors he wanted, and he wanted the drugs he wanted. And there's another thing. He was very good at getting what he wanted. He had been an opioid addict for a long time. We now know that. And he had become very good at manipulating doctors. He used those same skills for another drug, propofol. Mr. Jackson is responsible for his health. He is responsible for his health care. He is responsible for his choices. He was a grown man. Mr. Jackson's health care was not AEG Live's job. And it certainly wasn't Kenny Ortega's job, no matter what they claimed yesterday. Remember Mr. Ortega's actual testimony? Adults are responsible for their own health. I didn't think Michael Jackson was being very responsible, but it was his responsibility. That's what Kenny Ortega said. And you can't say Kenny Ortega didn't love and care for Michael Jackson. What you have to remember here is that Michael Jackson chose Dr. Murray, and Michael Jackson chose propofol. And let's talk about Mr. Jackson's history with propofol a little bit, or what we were able to learn from the limited records we could get. And what we were able to learn is it's unquestionably a long history, and it started years before this is it. You heard from Debbie Rowe that Mr. Jackson received propofol for sleep in 1997 in a hotel in Germany. Dr. Metzger lined everything up and had doctors come to Mr. Jackson's hotel room to give him propofol for sleep. And Mr. Jackson chose this drug. That was Mr. Jackson's choice. How do we know? Ms. Rowe said propofol was Dr. Metzger's second choice in Germany. It's not what he wanted to do. It wasn't his first choice. It was Mr. Jackson who wanted it. Adults are responsible for the choices they make. Debbie Rowe warned Mr. Jackson that propofol was dangerous. Remember, she asked Mr. Jackson, what happens if you die? And even the doctors in Germany told Mr. Jackson, quote, you can't do this. We're not doing this again. Now, plaintiffs don't want to admit that fact. You heard Mr. Panish tell you that the first time Mr. Jackson received propofol outside of a hospital setting was from Dr. Murray in 2009. That's what he said. It's not true. It was more than 10 years earlier. Mr. Jackson was using propofol for sleep more than 10 years before this is it. He chose it. He alone is responsible for that choice. And it wasn't just on tours. To try to say it was a tour issue, it's not true. Remember in 1998 or 99, it's unclear from the doctor, when there was no tour, we know that, there's nothing going on, and Mr. Jackson asked Dr. Christine Quinn, a dental anesthesiologist, his dental anesthesiologist, if she would give him propofol for sleep. He had a son, Prince, with him. You remember there at the hotel? Prince was 2 years old. You heard her story. Mr. Jackson asked Dr. Quinn's sister, who they'd never met before, to watch his young son while he went into another room with Dr. Quinn. And then he asked Dr. Quinn for propofol for sleep. 98, 99, no tour. He knew propofol by name. He told Dr. Quinn it was the best rest he'd ever had. This was the late 90s. But she told him no. Dr. Quinn said no. It's not real sleep. That's what she said. It doesn't solve the problem of being tired. And she told him it's not proper to use propofol outside a medical setting. It's not safe. And Mr. Jackson told Dr. Quinn that he knew he wasn't getting real sleep from propofol. That's what he said. He knew he wasn't getting real sleep. This is in the late 90s. He understood this. He admitted he knew it wasn't real sleep, but he wanted it anyway. He chose it anyway. And this was 98 or 99. This was not 2009. Now, plaintiffs don't want to admit that either. That's why you heard Mr. Panish tell you in his opening statement that Michael thought he was getting real sleep from propofol. So they said in the opening. But that's not true. Dr. Quinn told you otherwise. And he knew it. In 2002 or 2003, Mr. Jackson asked Dr. Van Valen for the same thing. Mr. Jackson wasn't touring in this time period either. And when he asked Dr. Van Valen for that, Michael Jackson had a box full of bottles of propofol in his bedroom. And he showed them to Dr. Van Valen. Do you remember that? He asked Dr. Van Valen, he pulled out a box of propofol. Mr. Jackson had them. Dr. Valen didn't bring them. Mr. Jackson told Dr. Van Valen he had used propofol to sleep on many, many occasions. All those years between shows on tours. Now let me remind you exactly what he said.
Did Michael Jackson ever discuss Diprovan with you?
Yes, he did. And he had a box. He had a box of it in his room, and he said, "Now this is the stuff, Diprovan." He said, "I used to use this between shows on my world tours," and he said, "I had a doctor there that would put in the IV and put me to sleep, and he'd stay there for 8 hours and wake me up, because I would go, if I had 3 days between the shows, I would have 3 days I didn't sleep, and then I couldn't put on the show I wanted to have. I mean, I want my shows to be as high end as possible, and so anyway, for whatever how many years he toured, he got IV Diprovan from a doctor who was on a tour, but obviously this doctor monitored him,
Dr. Van Valen. He didn't even know what propofol was when Mr. Jackson asked him to give it to him. He was a doctor, and he didn't know what it was, but Mr. Jackson did. And Dr. Van Valen testified he had never heard of anything or anyone doing this before, and he was a family doctor. He had to call an anesthesiologist to find out what propofol was. He hadn't heard of it, and when he asked, he found out just how dangerous it was. That's why Dr. Van Valen refused to give it to his good friend, Mr. Jackson, just like Dr. Quinn did. And just like Dr. Quinn, Dr. Van Valen warned Mr. Jackson. He said, propofol is dangerous. It should never be used outside an operating room. It should never be used without an anesthesiologist present who specializes in it. That's what he told him. He told Mr. Jackson that without proper monitoring, a patient can stop breathing and die of propofol. And remember, this is 2003, 2002, in that period. This is not 2009. And Mr. Jackson isn't going on tour, not in that period, but he still wants his propofol. He's got a box of it at home. Michael Jackson was told over and over and over again that propofol was dangerous. It wasn't real sleep. It could kill him. But he wouldn't take no for an answer. If one doctor said no, he'd just go to another. And he was good at shopping for doctors who would give him what he wanted and who would say yes. Did a warning that he could die stop Mr. Jackson? No. He kept asking, and more doctors told him propofol was dangerous. In 2009, Dr. Metzger warned Mr. Jackson that giving sleep medication through an IV is dangerous and potentially life-threatening. And you know what? He was right. 2 months later, Mr. Jackson would be dead. And that didn't stop Mr. Jackson, because the very next day, the very next day, that's April 18th, April 19th, very next day, he asked Sherilyn Lee for the same drug, the very next day. He had just been warned that it was life-threatening by his doctor and friend of 30 years. You heard Dr. Lee's emotional testimony. She said no, too, just like Dr. Quinn, Dr. Valen, and Dr. Metzger. But she went further. Like Dr. Van Valen, Dr. Lee also didn't know what propofol was. And when she found out, she was startled. And she told Mr. Jackson that propofol was not a safe sleeping aid. That is not supposed to be used at home. And anybody that would administer it to him for sleep, they didn't care about him. Finally, Dr. Lee told Mr. Jackson that using propofol could kill him. The bottom line was death. That's what she told him. And tragically, she too was right. Remember, she argued with him for hours, but she couldn't convince him not to use propofol. He wouldn't take no for an answer. Mr. Jackson was warned by at least 5 people of how dangerous propofol was, at least 5 we could find. Mr. Jackson heard these warnings. He understood them, and he ignored them. And he continued to seek out propofol like he had done for more than a decade. Seeing this evidence, it is ludicrous for plaintiffs to now argue that Mr. Jackson only took propofol because he had a misplaced trust in doctors, or that he was suddenly overwhelmed by the This Is It tour preparations. He heard the warnings, he understood the warnings, he chose to ignore the warnings. When doctors refused to give Mr. Jackson what he wanted, he doctor shopped. And he cut uncooperative doctors out of his life permanently. This slide contains every medical professional we can prove treated Mr. Jackson, the ones we could find, the ones we could get information from. Remember Mr. Fournier, the nurse anesthetist? I'm going to screw it up again, Catherine. The nurse anesthetist, you know what I mean, who had taken care of Mr. Jackson for 10 years. Remember when he came in? Mr. Fournier refused to administer propofol one time. He refused one time to Mr. Jackson because he thought he was on other drugs. Propofol. And remember the prior time Mr. Fournier saw Mr. Jackson, he'd stopped breathing during a procedure. That was the prior time. So this time, Mr. Fournier was justifiably concerned. But Mr. Jackson denied it. He said he wasn't taking anything else. And after that, Mr. Fournier never heard from Mr. Jackson again. Remember Dr. Stephen Gordon? He testified that Mr. Jackson asked him for 300 milligrams of Demerol for the road after a procedure. Dr. Gordon refused. He didn't hear again from Mr. Jackson for 4 years. What about Sherilyn Lee? Dr. Lee had been in his home for dozens of times in the prior 4 months. When she said no to propofol, that was the last time she set foot in Mr. Jackson's house. Mr. Jackson also manipulated the doctors he did see into giving him what he wanted by not telling one doctor what another was giving him. Remember the incident with Dr. Van Valen? When he gave Mr. Jackson a shot of Demerol and then noticed that bloody spot on his shirt from another shot, Dr. Van Valen knew it was a shot from another doctor and that Mr. Jackson was doubling the dose. Dr. Van Valen warned him that this could kill him. Remember the incident with Dr. Saunders? When Mr. Jackson had to go to the emergency room? Dr. Saunders gave him a shot of Demerol, and Mr. Jackson had what seemed to be a bad reaction, and then revealed that another doctor had given him one earlier. The only reason Mr. Jackson was able to get these dangerous double doses is because he lied to his doctors. He didn't tell them what he was getting from one or the other. Your doctor can't treat you properly if you aren't honest with them. You heard about Mr. Jackson's secrets from Dr. Metzger, his longtime friend and doctor, from Dr. Saunders, also his friend, from Dr. Van Valen, also his friend. Dr. Metzger, who had treated him for decades, never even discussed with Mr. Jackson that he had went to rehab. Do you remember that? Asked him, did you discuss rehab with him? No. How did you learn about it? Saw it in the New York Times. Did you talk about him with it afterwards, the next decades where you were his doctor? No. Mr. Jackson was smart. He had decades of experience getting the doctors he wanted and getting the drugs he wanted from those doctors. Adults are responsible for their own choices. Michael Jackson was going to get propofol no matter what because he chose to seek it out, because he wouldn't take no for an answer, because he wouldn't listen to the warnings. AEG Live had nothing to do with that. They had nothing to do with Michael Jackson's choice to take propofol. How do we know that? Well, let's look at all the things that happened before Michael Jackson even mentioned Dr. Murray to AEG Live and told them, I repeat, and told them that he was taking his doctor on tour. We know Dr. Murray moved to California to treat Mr. Jackson before AEG Live had ever even heard of him. By January 25th, 2009, Dr. Murray was prescribing medicine for Mr. Jackson's children for colds here in California. And we know Mr. Jackson told Dr. Murray he was going on tour with him by March at the latest. It may have been earlier, but we know it was by March. How? Because in late March, Dr. Murray and Mr. Jackson met with the anesthesiologist, Dr. Adams, in Las Vegas to interview him about coming on tour with them and using IVs to, quote, help Mr. Jackson get his rest, unquote. Dr. Murray was already coming on tour at this point, regardless of AEG Live. And he and Mr. Jackson were already planning for Mr. Jackson to get IV propofol to sleep, all before AEG Live had ever heard of Dr. Murray. Now we get to some really important dates. April 6, 2009. Dr. Murray ordered propofol and had it shipped to Los Angeles. Again, this is still before anyone at AEG Live had ever heard the name Dr. Conrad Murray. So we know that before AEG Live had ever heard of him, Dr. Murray had moved to California, had been asked by Mr. Jackson to go on tour, had accepted, was interviewing doctors to help him give Mr. Jackson propofol, and had already ordered propofol. And plaintiffs are saying AEG Live caused this? No, this was already happening. And it was happening regardless of what AEG Live would later do. Now, what happened when AEG Live finally heard the name Dr. Murray? It happened at some point in the second half of April. We know it was after April 13, 14, or 15, because Paul Gongleware said it was after the dancers had their tryouts. Mr. Jackson told Paul Gongleware he was bringing his personal physician, Dr. Murray, on tour. Told him that. And he asked Mr. Gongleware to call Dr. Murray to see what he would charge. So Mr. Gongleware called Dr. Murray, and he asked him. And Dr. Murray said $5 million. And Paul Gongleware said, no way. Boom, done. Over. It's not happening. So what does Dr. Murray do? Did he back off of what he was doing because he thought AEG Live wouldn't be advancing him the money now if he ended up going on that tour? No. He ordered more propofol. On April 28, 2009, Dr. Murray made a second order of propofol and had it shipped to Los Angeles. At this point, Dr. Murray certainly didn't know he had a contract with AEG Live. There's no way he could have. He'd just been told no way. But he still ordered the propofol for a second time because it was what his client, Michael Jackson, wanted. Mr. Panish wants you to believe that despite Dr. Murray ordering propofol twice in April, that Dr. Murray never administered it. That's what their claim is. Oh, but he didn't give it to him then. Again, the evidence does not support that. Why would Dr. Murray need to order more propofol if he hadn't used what he already ordered? And don't forget Kai Chase, who saw Dr. Murray at Mr. Jackson's house multiple times a week from the very beginning of April, just after she started work, carrying those oxygen tanks down the kitchen stairs. That was her testimony. That's what she saw in early April. Now, Mr. Panish told you yesterday that Ms. Chase said that there were no oxygen tanks in April, only in June. It's not true. The only so-called evidence that Mr. Panish has that Dr. Murray was not giving Mr. Jackson propofol in April is that Mr. Jackson asked another two people for propofol in the same time period. Remember, that was the argument? Dr. Murray couldn't have been doing it because he went and talked to Dr. Metzger and went to talk to Dr. Lee. On April 18th, he asked Dr. Metzger for IV sleep medication. That's true. On April 19th, he asked Cheryl Lynn Lee for propofol. We don't know why. Because Mr. Jackson didn't tell AEG Live about Dr. Metzger or Dr. Lee ever. You've heard that Dr. Murray wanted an assistant, a backup nurse or a doctor to take to London with him. Maybe these were interviews for that backup person, just like Dr. Adams, who they talked to. Maybe Mr. Jackson wanted someone to give him propofol on Dr. Murray's days off. It seems plausible. After all, if you recall, we know he saw Dr. Metzger on April 18th. That's a Saturday. And Dr. Lee on April 19th. That was a Sunday. And we also know that Dr. Murray didn't work Sundays. So maybe he was looking for someone to give him propofol on the days when Dr. Murray wasn't there. Whatever the reason, this is not evidence that Dr. Murray wasn't administering propofol. Why else would he be there all night with oxygen and reordering a second shipment of propofol in Los Angeles in April. You know why. And Dr. Murray continued to order propofol for Mr. Jackson on May 12th and again on June 10th. Now, you're going to be asked to consider all of these facts and decide, would this have happened without AEG Live's conduct with Dr. Murray? Well, let's look at AEG Live's conduct with Dr. Murray. If AEG Live had refused to advance Dr. Murray's salary when Mr. Jackson asked them to, would this still have happened? Yes. Before AEG Live ever heard of Dr. Murray had already moved to California. Mr. Jackson had already asked Dr. Murray to go on tour. Dr. Murray had already accepted. Dr. Murray had already ordered propofol. He had already started administering it to Mr. Jackson. Dr. Murray made all 4 of the propofol orders he ever made for Mr. Jackson before June 20th. Before that meeting that we talked about that happens the day after the 19th, before that telephone call, and at least 3, and likely all 4, were before the early June meeting as well. All you have to do is look at a calendar to see there is no connection whatsoever between Dr. Murray ordering propofol and any action by AEG Live. Plaintiffs try to argue that Dr. Murray did what he did because of a conflict of interest, because Dr. Murray felt pressure from AEG Live to return Mr. Jackson to play before he was ready. It's a very clever theory, but the evidence just doesn't support it. Plaintiffs claim Dr. Murray was influenced by a cancellation provision in the draft written contract. Remember, they kept saying there's a cancellation provision. That's why there was a conflict. He had never even seen that contract before June 16th. That's the first time he saw that draft. He'd been ordering the propofol forever at that point. After he'd already ordered the 4 shipments. All the propofol that he ever ordered happened before that. That wasn't a result of a conflict. Dr. Murray didn't do this because of AEG Live or some pressure he felt from AEG Live. He did it because it was what his client, Mr. Jackson, wanted. Even plaintiff's own expert, Dr. Matheson, he admitted that there was no connection between a conflict of interest and Dr. Murray's decision to order propofol for Mr. Jackson. And remember, it wasn't AEG Live's job to manage Dr. Murray's potential conflicts that arise all the time in medicine. Dr. Green told you that the American Medical Association and every other professional organization places that responsibility squarely on the physicians. Conflicts exist all the time. It's the doctor's job to manage them. Plaintiffs want you to believe that there is some connection with AEG Live, and there's not. Plaintiffs argue AEG Live should never have agreed to advance the money to Dr. Murray should he have ever gone on tour. That AEG Live never should have agreed to draft a contract with Dr. Murray in the first place. That AEG Live should have refused to advance the money for Mr. Jackson's personal physician. But there was no conflict of interest here. The only interest AEG Live had was in Mr. Jackson being healthy and able to perform on tour. That's their interest. And the arrangement that was going to exist here wasn't some secret third-party agreement where Mr. Jackson wouldn't know who was paying his doctor. That would be a problem. Mr. Jackson asked AEG Live to pay his doctor on his behalf. Mr. Jackson set the salary. And Dr. Murray knew that as well. When Paul Gongwer called him, he told him the offer of $150,000 a month was, quote, direct from the artist, end quote. Even Dr. Matheson admitted that Mr. Jackson, as an adult, had the ability to consent to an arrangement where AEG Live paid his doctor. That's their expert. And those contract terms that Dr. Matheson was so concerned about, Mr. Jackson had to approve those as well. Remember, there would be no agreement between AEG Live and Dr. Murray unless Mr. Jackson approved the arrangement, including all of the contract terms in writing. There was no secret dangerous conflict. And let's pause for a moment and think about what Mr. Panish says AEG Live should have done. He says they should have just given Mr. Jackson the money to pay Dr. Murray instead. But even if Mr. Jackson paid Dr. Murray, out of money AEG Live gave him, it wouldn't have made any difference. Mr. Jackson still would have asked for propofol. Dr. Murray still would have given it to him. And Mr. Jackson still would have died. The sad truth is that Mr. Jackson was bound and determined to get propofol, an invisible drug, with impossible to see consequences. And nothing would have stopped him. Adults are responsible for the choices they make. So if you get to this question, if you get to question 5 in the form, asking whether AEG Live's conduct in hiring, retaining, or supervising Dr. Murray was a substantial factor in Mr. Jackson's death, I think the only answer can be no. Now, if you go through all of that, if you say yes on all of those, that gets you to damages. I now want to say a few words to you about damages. There's no reason you should get to this question, in my belief, given the evidence in this case. To get to this point, you'll have to decide that AEG Live hired Dr. Murray, that Dr. Murray was incompetent to be Mr. Jackson's primary care doctor, that AEG Live knew or should have known what Dr. Murray was actually doing, and that AEG Live's interactions with Dr. Murray caused Mr. Jackson's death. You have to say yes to all that. That's a lot of ifs. But we have to talk about the amount of money plaintiffs are requesting in this case, because it's ridiculous. $1.5 billion. 1.2 is economic. 340 million is non-economic. The judge instructed you cannot award damages based on speculation. If you get to this and you need to do damages, it can't be on speculation. It can't be guesswork. It's not how it works. And that's all plaintiffs' 1.5 billion in damages are, speculation and guesswork. Think about it for a moment. As I said in the beginning, plaintiff's entire case is that Mr. Jackson was so obviously dying of a terrible drug addiction that it was obvious to everyone. They say AEG Live should have known Dr. Murray was going to kill Mr. Jackson. It was obvious. But then they turn around and say Mr. Jackson would have done hundreds more concerts, well into his 60s, and he would have made billions of dollars. They can't have it both ways. That, members of the jury, is the definition of speculation. Which is it? He was so sick it was obvious? Or he was so well he would have earned more money than he ever had in his lifetime? How can plaintiffs claim it's not guesswork that Mr. Jackson would have made $1.2 billion? Well, you remember Mr. Irk, right? Their expert? He was their damages expert. Normally his job is to determine whether some show or movie paid enough in royalties. He'd never done anything like the calculations he did in this court before. Mr. Irk says Mr. Jackson was going to perform 260 shows on the This Is It tour, more than any he had done on any tour in his entire life, even in his 20s. And 210 more shows than anyone had agreed to do at the time of Mr. Jackson's passing. And Mr. Irk says he was going to go on to do something neither Mr. Jackson nor any other performer has ever done in history. 5 world tours, performing a total of 455 shows from the age of 50 to 66. Even though Mr. Jackson performed only a fraction of that during his entire solo career, from his 20s through the age of 50. Even though he told everybody that This Is It would be the last tour that he ever did. The judge instructed you, you don't have to believe an expert's testimony. You have to consider the facts that the expert relied on. Plaintiffs never showed Mr. Irk any of the evidence showing that Mr. Jackson had a secret drug problem for decades before his death. Not just propofol, but also Demerol. They never showed him that. We asked him. To Mr. Irk, those were just media reports. Remember this we said? Those were media reports. He wasn't looking at that. Is that a search for the truth? No. Plaintiffs never told him about Mr. Jackson's drug abuse because they wanted him to come up with the highest number possible. And they did. $1.2 billion. Now, I'm not saying that Mr. Jackson would never have made another penny. That's what they tried to say yesterday. We've never said that. Mr. Briggs didn't say that. But what he said, and what we are saying here, is that what they've shown you is speculative. They had to prove to you something, and they didn't. The only thing agreed to at Mr. Jackson's death was 50 shows. That's true. And that was going to be true if and only if those went well. There might be more then, but that's speculative. We don't know. Because of Mr. Jackson's history of failed projects, which you saw. Because of his drug use and this game of Russian roulette that he was playing. When you consider the billions of dollars that plaintiffs are asking for, remember this chart. Can you say, without speculating, without guessing, that the This Is It tour was going to gross more than twice as much as the highest grossing tour of all time? Can you say without speculating that Mr. Jackson would have netted more than any tour for any artist in history when his prior tours had both lost money? That's speculation. Plaintiffs want you to ignore all that. They're asking for billions of dollars in the hope that Mr. Jackson might be able to pull off something no one had ever done before. That is the definition of speculation. Now, if you decide to award any economic damages here, and I certainly don't believe that you should, then you have to base it on reality, on what Katherine Jackson and Mr. Jackson's children actually lost. What would Mr. Jackson have given them? Because remember, the figure isn't what he would have earned. So what would they have received? Economic damages must be based on the amount of support Mr. Jackson would have actually given to plaintiffs. The judge told you that on Monday. And the only witness who came up here and told you about a number was our expert, defendant's expert, William Ackerman. Remember him? He's the one who reviewed the hundreds of thousands of pages of Mr. Jackson's prior financial documents that Mr. Irk didn't bother to go through. That's why our experts are so expensive. They actually do the work. He found Mr. Jackson was broke, more than broke. He was in a huge hole, and that is a fact. In fact, Mr. Jackson was on the verge of bankruptcy. By the time he died, he was spending $20 million more per year than he earned. So Mr. Jackson borrowed money, a lot of money. And when he passed in 2009, he was well over $400 million in debt, and that is undisputed. Had Mr. Jackson lived, it's difficult to see how he was going to get himself out of that hole, and it had to be daunting. And that's even if he went on tour, even if he successfully completed the 50 shows in London. That's why Mr. Ackerman testified that he wasn't sure whether Mr. Jackson would have been able to give plaintiffs anything had he lived. That's why he said that. It wasn't that Mr. Jackson wouldn't earn anything. He had a $400 million debt to take care of. Remember, he had to service that debt. He had to service that mammoth debt before he was going to be able to give his family anything. And remember, that's what you're trying to determine, what Mr. Jackson would have given plaintiffs had he lived. But Mr. Ackerman did try to measure what that support might be if he could. He based his numbers on what Mr. Jackson had actually been given his mother and children before he died. And even then, as he told you, he was extremely generous. When in doubt, he went high. Now, Mr. Panish told you yesterday that that figure was $59 million. Said that a couple times. That was just made up. Made it up. Mr. Ackerman actually determined if Mr. Jackson lived for one more year, it would have been $1.6 million. If he lived 7, it would have been $15 million. 16, $21.5 million. And that was the total for all 4 plaintiffs. $21.5 million. That's a lot of money by any standards. $21.5 million. More money than most people will ever see in their lives. But that's nowhere close to $1.5 billion. Plaintiffs want you to believe that Mr. Jackson was going to change his stripes. The man who blew through $115 million in less than 3 years in the 90s was suddenly going to become prudent with his money. But you have to look at the evidence. In June 2009, Mr. Jackson was living in a mansion that cost $100,000 a month, while his mother's home was going into foreclosure. He had nearly $500 million in debt and was still borrowing more whenever he could. There's simply no reason to believe that he was going to change. That's damages. Now, if you find all those, find damages and everything else, well, then you get to our defense. And that's that Michael Jackson was a substantial factor in his own death. Now, that's after you've shown everything else. okay? And with most questions in the verdict form, if you answer no, then you're done. You stop. The case is over. But if you keep answering yes, eventually you'll be asked to decide whether Mr. Jackson was negligent. And if so, was that negligence a substantial factor in his death? And here, the answer must be yes. And that's because the judge instructed you that, quote it, did you tell me to read, Jess? Sorry. Can you pull that up, Ken? Sorry. A patient must use reasonable care to provide for his or her own well-being. To succeed, AEG Live must prove both of the following: that Michael Jackson did not use reasonable care to provide for his own well-being, and that Michael Jackson's failure to use reasonable care in connection with his medical care was a substantial factor in causing his harm. So the judge instructed you that if Mr. Jackson didn't use reasonable care to provide for his own well-being, he's responsible for his own death. Even plaintiffs admit this is true. Even they admit that Mr. Jackson is at least partly to blame here. I've already spoken to you about how Mr. Jackson sought out propofol from doctors for years. Now let's take a step back, however, and look at this more generally. Who was responsible for Mr. Jackson's health? Was Mr. Jackson responsible? His doctor? Certainly not his concert promoter. An adult chooses his own doctor. That's what Dr. Matheson said, plaintiff's expert. He agreed with Dr. Green, Mr. Ortega, and Mr. Gongaware. They said the same thing. An adult is responsible for his own health. AEG Live had no right to override Mr. Jackson's choice. AEG Live could not make Mr. Jackson go to a doctor he didn't want to see. Here, Mr. Jackson chose Dr. Murray. He was responsible for that choice. Remember Mr. Ortega? Mr. Ortega testified he believed Mr. Jackson's health was Mr. Jackson's own responsibility, even when he wasn't being very responsible. And even Katherine Jackson, Mr. Jackson's mother, admitted his drug problem was his responsibility. When she thought he had a problem, she confronted Mr. Jackson about it. Not his concert promoter, not his doctors. She confronted Mr. Jackson. He had the power to stop his abuse. And then, in addition, Mrs. Jackson made sure no one knew about Mr. Jackson's issues. You remember that whole People magazine thing? Mr. Jackson didn't want the truth to come out about his problem. So Mrs. Jackson didn't want the truth to come out about her son's problem. So they signed that thing saying these are all lies about him and drug abuse. He wanted to keep the secret from the world. She wanted to keep the secret from the world. He wrote it. She signed it. Now, plaintiffs have tried to present Mr. Jackson as powerless, like he's a child. The boy we all remember from the Jackson 5, or some of us. But that's not who he was. He was a grown man, and he made his own choices. I'm not going to rehash everything we've been through today. I'm sure you're glad. But you know that Mr. Jackson chose Dr. Murray. You know he chose propofol. You know that was Mr. Jackson's choice. And this is not about blame. It's about responsibility. Mr. Jackson was a 50-year-old man. He had many, many chances to put himself and his life on a different path. He didn't take them. Mr. Jackson knew the consequences of abusing propofol. If you make it this far in the verdict form, then you have to decide that AEG Live was to blame. Then you've decided that AEG Live was to blame for Mr. Jackson's death. And if you've decided that, then you have to decide how much responsibility Mr. Jackson may bear. And that percentage, I believe, should be very, very high. Mr. Jackson, like all adults, is 100% responsible for the choices he makes. Mr. Jackson told you yesterday that you should assign Dr. Murray's share of the blame to AEG Live. But you should only do that if you believe AEG Live was 100% to blame for Dr. Murray's actions. If you believe Mr. Jackson selected Dr. Murray, and he did, if you believe he asked for propofol, and he did, if you believe he paid Dr. Murray, and he did, then you should assign responsibility for Dr. Murray to Mr. Jackson. Members of the jury, it's a long 5 months. Probably no one knows it better than y'all. You've been incredibly patient and incredibly attentive. And you have heard a lot of evidence here, a lot. I want to remind you of a few key points about the questions you're now going to have to answer. That form that you're going to fill out, the only way to find for plaintiffs here is if you find they have proved all of the elements of their claim. That's their burden. Not just hiring, not just unfitness, not just notice, not just causation, and not just damages. All of them. And they simply haven't done that. Now, this is the last time I get to talk to you all. You're going to hear from Mr. Panish one more time after I finish, because plaintiffs, they have the burden of proof, so you're going to hear from him tomorrow. But I'm not going to be able to come up here afterwards when they're done and tell you if there are any facts that aren't quite right. I'm not going to be able to object and say, no, 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 that's not true. So you need to be really vigilant tomorrow. Listen to what he says and see if it lines up with the testimony and evidence that you've seen and heard during this trial. And I say this because I remember all the important things he got wrong yesterday. I bring this up to you because you remember he said, don't worry, I'm sure they'll correct me if I'm wrong. And remember he said that a bunch of times during trial, don't worry, if I'm wrong, they'll correct me. I can't do that tomorrow. You got to. And we beg you to do so. Because just yesterday he said the following, that AEG Live was paying Dr. Murray. It never happened. AEG Live was bringing Dr. Murray on. Didn't happen. When Dr. Murray started working in California, they said May, January. Dr. Murray not having oxygen tanks in April, he did. Mr. Panish's own witness said so. No doctors giving Mr. Jackson propofol for sleep before Dr. Murray, they did. Mr. Irk getting numbers from AEG Live, he didn't. Mr. Ackerman's damages figure, he was wrong by $40 million. And those are just the big ones. I'm not going through them all. But you got to. So please listen attentively tomorrow and see what is proven, what's put in context, what is so, and what aligns with what you actually know, because you've been here for 5 months. Look closely tomorrow. If it doesn't sound right, or it sounds incomplete, please check it, because it very well might be wrong. And I'm trusting y'all to get it right. So let's talk one more time, just one, about what plaintiffs have to prove. Plaintiffs have to prove that AEG Live hired Dr. Murray. We've seen the evidence, and that shows it never happened. Michael Jackson hired him a long time ago, and he was never hired by AEG Live. They didn't prove this, and it's their burden. Plaintiffs have to prove that Dr. Murray was unfit or incompetent for the job he was hired to do. That's the standard, for the job he was hired to do. So if it was AEG Live who hired him, it wasn't to give Michael Jackson propofol. But Dr. Murray wasn't unfit or incompetent to treat Michael Jackson's general medical needs. And plaintiffs haven't proven this element either. Plaintiffs have to prove that AEG Live knew or should have known that Dr. Murray was unfit or incompetent for the job he was hired to do. There's no evidence of this. They can't do it. Because whatever was going on with Mr. Jackson, it wasn't noticed that his doctor was a bad doctor. That's what it would have to be. Remember, those closest to Mr. Jackson, and that wasn't AEG Live, those closest to Mr. Jackson, his makeup artist, his chef, his son, people who were in the house, even they didn't suspect Dr. Murray. But AEG Live was supposed to? And plaintiffs have to prove that AEG Live's conduct with regard to Dr. Murray caused Mr. Jackson's death. And they certainly can't do that. Because Mr. Jackson was using propofol long before Dr. Murray. And Dr. Murray was giving propofol long before AEG Live was around. Remember those propofol orders. Remember that timeline. Over and over again. And all before Dr. Murray saw a draft of his contract. Before he ever met with Mr. Phillips or Mr. Gongaware. Before even that first call. Lastly, they got to prove damages. Can't speculate, got to prove. Did they prove damages to you? No. They haven't done so. Mr. Jackson selected this doctor. Mr. Jackson demanded this doctor. Mr. Jackson asked for the drug that killed him. Mr. Jackson hid his problems from anyone that could help. His family, his staff, and most of all, his concert promoters. Members of the jury, what happened to Mr. Jackson was a tragedy. I'm not trying to say anything that says that's not so, because it was. And it's understandable that plaintiffs want to blame somebody. I get it. But it was not AEG Live's fault. All they were trying to do was put on a concert. You can't hold a concert promoter at fault for Mr. Jackson's choices. It was Mr. Jackson's secrets and his choices that has brought all of us here. You've been asked to do something very, very serious. You've been asked to decide if AEG Live killed Michael Jackson. That's what you've been asked.
Sustained. Okay, sustained.
If they had a role in the death of Michael Jackson. Please look at the evidence, the actual evidence, and think about the last 5 months. Think about all you've heard. Think about all you saw. When you do, it is my very sincere hope, it's my belief, that you won't blame AEG Live for Michael Jackson's death. Thank you.
Ladies and gentlemen, tomorrow I need you back here at 9:45, but I need you to speak to the deputies before you leave because you're going to report to this room instead of Department 28, and they're going to get you here. So before you leave, speak to them. They're going to speak to you as a group, so don't leave before you speak to them, okay? All right, so 9:45. Council, we need to meet at 9:30. I think this room will be available, so I'm going to ask that we meet here. I'm not 100% sure if this room will be available at 9:30. If not, I will send the clerk up here to send you to Department 28. But as far as I know, this room will be available at 9:30 tomorrow. So I need to speak to you just 15 minutes before we start. Okay? All right, thank you. Everybody have a good evening.